Please welcome tonight's host, Mark Rossman, for some introductory remarks. Ask everyone to mute their microphones as our program has begun. Please be sure to mute your microphone, and we will begin our program shortly.
I was looking through the, there's a baby crying. I was looking through the roster of participants here tonight, and it's really strong. Start over? Okay.
Come fly with me, let's fly away. If you can use some exotic booze, there's a bar in far Bombay. Come fly with me, let's fly away. Come fly with me.
All right, so we're back to the third annual Symposium on Corporate Oppression. I fully planned for a few technical glitches because I don't see why this would be any different from when I appear in court over Zoom or at a mediation or in a deposition, and everything goes awry the second you turn it all on. So we heard the baby crying. I think we heard some lawyer jokes in the background, so that was good. Maybe someone can complete the punchline a little later on. But as I was saying, it's great to be here in Grand Rapids at Fortz Legal for the third annual Symposium on Corporate Oppression. I'm so excited that we're 25 strong speakers. I mean, these are people you're really going to want to hear talk if you're involved in business law, or, and I looked on the roster tonight, we have several business owners in attendance, virtually, of course. And I tell you what, if I was their majority partner, I'd be concerned about them coming to this business divorce seminar. So we have law professors and law students with us tonight too, because the State Bar opened up the registration for the program to the law students. So the title of the program is Oppression in the Age of the Pandemic. And I've gotten the question over and over, well, what should we speak about? What does the pandemic, how should we fit it in? Well, the answer to that is the pandemic really affects everything. It's why we're doing this virtually tonight. And on a positive note, it's why we were able to get so many people able to speak, not having to deal with the logistics of actually going somewhere to do it. So in that sense, it's great. Now, what's the effect of the pandemic on businesses and partnerships? Because that's particularly what we're here to talk about tonight. How we litigate, how we manage the fiduciary component of a business relationship. Well, the pandemic has a way of peeling back fictions that businesses might have been living in prior to an era when we have to tighten our belts like never before, where very difficult decisions need to be made, where there's restructuring, where the perception that a change that might have needed to occur in the future because the status quo was okay is no longer there. And partnership disputes will rise as a result of this. So have risen. I've seen it with my own eyes. There's a lot of situations with employees, and litigation is blowing up in that area. And the partnership relationship, the fiduciary relationship, is no exception to the effect that the pandemic has had on business. So the structure of tonight's agenda, and we sent it out recently, is designed to track, in a rough way, the progress of the case. I'm making some introductory remarks for a little while, principally so we can get the technical glitches worked out, so that when 4 o'clock hits, we can go bang, 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 and get all these different programs in before 8 o'clock tonight, and then again tomorrow night on night 2. So we're going to start with a roundtable. And the roundtable is going to discuss the pre-filing due diligence that goes into these types of cases, corporate governance and early discovery strategies. You'll hear RJ Cronkite, Bernie Fuse, Tom Frazee, Sean Fitzpatrick speak on this, and I'll moderate that roundtable. Then we're going to move into the second roundtable, which will discuss mediation and negotiation strategies, which are so important, not just at the tail end of a case or in the thick of a case, but right at the beginning, because as we know, the business courts do tend to refer these matters to mediation quite swiftly. And we'll hear mediators John Frank, David Hansma, and Bill Winston speak on those issues, and the roundtable moderator will be E. Powell Miller. Then we'll do our third and final roundtable for the night on trial preparation and trial strategies. And in that roundtable, we'll hear from Norman Ankers, John Below, E. Powell Miller, H. Joel Newman, and Ian Williamson. The moderator will be Bernie Fuse. Then we're going to move into the lectures for the evening, and we're going to hear from two professors, Professor Douglas Mall from the University of Houston Law Center, and Professor Eric Zaks from the Wayne State University Law School. Professor Mall will give us an overview of oppression law, kind of a landscape, and Professor Zaks will discuss an interesting rule that we all should know and know well, the business judgment rule, and the pleading standards and how it applies at the pleading, early pleading phase of the case. And then we'll hear some dialogue with the two professors from 6:50 to 7:10. And we'll have two more lectures to round out the evening. Bill Winston will give us the backstory of a very important case on corporate usurpation, production finishing versus Shields. It's a case that we see cited often in the context of when a majority partner or even a minority partner makes off with a business opportunity. I had the opportunity to discuss his involvement in that case during a mediation a while back, and I thought we could all benefit from that and enjoy it. And Ian Williamson will close the night discussing the Oppression Study Project, which is going on right now and could affect the contours of statutory and possibly case law precedent in this area. So, moving on, like I said, can we go to the next slide, please? I'm not sure if the baby crying drowned me out, but I was saying before that this is a symposium. And in a symposium, we really, really encourage audience participation. Join the discussion. Unfortunately, your comments won't be anonymous. I think, will we see their names when they post up there? Okay, your names will post, so, you know, keep it clean. We know who you are. The definition of a symposium here. Number 3, an account of a discussion meeting or of the conversation at it. A convivial meeting for drinking. How did that get in there? Would anybody really drink behind their screens at home in a symposium? Well, if anybody comes tonight, they will see a bar over here, which I'll stay far away from as the symposium host. I think I owe it to the group, but we'll be inviting everyone here to imbibe and also enjoy the catering from Carolina Low Country Kitchen, which we've had the last 2 years, and which is a great, great restaurant. So join the discussion. Let's hear your voices. You're as important as the speakers here tonight, and maybe even smarter than a few of them. Actually, I just speak for myself. So if we could go to the next slide. This is the man who would be smiling down if he sees us in this symposium tonight, Benjamin Cardozo. He wrote the famous lines that we heard all of our corporate law professors say, and if we had people in the room here tonight, I'd quiz you on what the case name was, but I can't do that unless anybody wants to put it in the chat box. But it's Meinhard versus Salmon, and he authored that when he was on I always get the New York courts confused, but the highest court in New York, and he wrote there of the punctilio of the honor, the most sensitive, and those words should really strike fear in fiduciaries. Because fiduciary status, fiduciary duty, it's a beautiful thing, but it's also a very dangerous thing when you're being held to that standard. And the statutes that have been written since, in my opinion, all flow from the language that we'll see on the next slide. And I'm not going to read it all, but there's some things in there that are particularly noteworthy to keep in mind when you're litigating this case, both from a plaintiff's side and from a defense side too. And it's really what that standard of fiduciary conduct is and how very, very difficult it is to prove in a court of law that it's been adhered to. Now, it can be done, but the problem for the defense in these situations is you probably don't get past summary disposition or summary judgment if you're in federal court unless you can prove that there was no fiduciary relationship to begin with, because the language from which the precedents and the applications of these statutes, the language of Justice Cardozo in this seminal case, adopted by the Michigan courts, indicates that fairness and honesty and doing the right thing in arm's length transactions and even the mores or the morals of the marketplace are not good enough. You can live up to all of those standards and be all of those things. And if you're a fiduciary, you can become embroiled in litigation that may or may not come out your way, but lasts a long, long time and costs a lot of money. If we can flip to the next slide, please. And there it is, not honesty alone, but the punctilio of an honor the most sensitive is then the standard of behavior. Flip it over. And there's even more of it. And so those are the words the plaintiff's lawyer in these fiduciary cases live by. Those are the standards that the fiduciaries are being held to. And whether this precedent or this statement is being applied, what we see are the principles and policies that flow out of them being embodied in statutes around the country. Our statutes here in Michigan are section 1489, and if I get this right, 4515 or 1542. I can't remember the LLC one. But what those statutes did when they were enacted is they created direct causes of action. And we'll hear some of our speakers talk about the differences between direct causes, derivative causes, the business judgment rule, how that intersects, and how we plead our case. In the pleading of the case, the prosecution of the case, starting with the pre-filing due diligence, is so important. And that's why we're starting in our first roundtable with a discussion concerning the pre-filing work that we can do here. The beauty of the corporate statutes is that we're not limited to litigation. There are moves that can be made before we enter a litigation. Corporate demands for documents, demands for meetings at which records can be made and questions can be asked, and all the rules under the corporate governance documents. And you can quasi-litigate your case before filing litigation, which is something that I find is very, very useful to initiate a discussion that could ultimately lead to a resolution in the matter, rather than running right down to the courthouse. When we get to the courthouse, we have a lot of people slated to talk tonight who can explain to us how the legal arguments work, how we apply our facts. And then tomorrow night, we'll spend a lot of time listening to judges talk about it from their perspectives from behind the bench. So with respect to logistics tonight, if you have any problems, call Fortz Legal. I'm going to give you that number right now, meaning if you get kicked out or you can't get logged in, and that number is 844-730-4066. And they'll be able to help you with any issues you have because they're bound to arise. So could we test the chat boxes right now and see if we can have somebody log in and we can get a little comfortable with seeing those? Or we'll work on that just to get it going, because part of this introduction is just to smooth out all the tech issues. There we go. All right, so people are chatting. All right, so that's working and that is up. And anybody can feel free to use it at any time. So if we can go to the next slide, please. All right, before we pause and let everybody get ready and have our first speakers join the program, I just wanted to make a few thank yous. First, since we're here on Veterans Day, or Armistice Day as it used to be called, thanks goes out to the armed services. And I'd like to thank the State Bar of Michigan,
So basically what that is,
and in particular Terry Shoup, Susan Udsema, Andrew Marks for helping us with the marketing of this program. They did a great job. The Wayne State University Law School, which is co-sponsoring this event, and Tish Browning, who every year serves as the liaison with the law school for this program, and in non-pandemic times coordinates the production of the Detroit program at Wayne State University. Margot Hyman and Cassandra Lee from the Wayne State University Business Journal, who's also sponsoring this program, and Eric Zach for agreeing to speak tonight from Wayne State University Law School. Thank Carolina Low Country Kitchen for providing the food. PJ Muir Productions, whose voice you'll hear over and over tonight as he helps us transition from one program to the next and give introductions and constant reminders to chime in and direct the discussion through our chat function. And of course, Fortz Legal for hosting this event, as it does every year in Grand Rapids, and also the lawyers back at my law firm who've given countless hours to putting this production together. So thank you all very much for joining tonight. Look forward to hearing from you, and we'll have a pause for how long? What time is it? About 5 minutes. We'll be ready to go with the first round table. So thank you very much.
Let's take off in the blue. Once I get you up there where the air is rarefied, we'll just glide starry-eyed. Once I get you up there, I'll be holding you so near. You may...
Our next topic involves one of the most important points in a case, the beginning. When facts come together for the first time and morph into a legal theory, the successful application of which requires sound due diligence and investigatory methods, application of corporate governance, or lack thereof in many cases, and earlier discoverer strategies which precede the filing of litigation. Presenting on this roundtable topic of pre-filing due diligence, corporate governance, and early discovery strategies is R.J. Cronkite, Bernie Fuse, Thomas Frazee, Sean Fitzpatrick, and Mark Rossman moderating. And please feel free to post dialogue and questions freely in the chat box throughout all of our discussions tonight.
Comments about ferns, that we should be sitting between them?
Yeah, I mean,
What's that all about?
well, we couldn't get the fireplace.
I better get my
That would
mask
be
on.
not legal.
All right, so do we have all our speakers here? Tom Frazee, are you in the house?
I am.
All right, Tom. I thought that
Oh, there he is, right there.
since I usually spend a lot of time answering your hard questions, I just kind of get the ball rolling asking you what it is that you like from lawyers at the beginning of one of these cases, these fiduciary breach oppression cases, as the expert who will ultimately possibly be testifying in the case.
Yeah, for me, this, and I say this with some seriousness, that I think the best thing to start with, frankly, is an introduction to the client, and the time to actually spend talking with that individual as to what it is that they're concerned about. One of the things, as you know, you deal with financial issues in a case like this, some of them end up relating to liability, some may relate to remedies that ultimately are valuation focused, or that may relate to damage claims or things like that. But my experience has been that really, you know, that first introductory discussion with the client helps to give you some understanding of sort of which bucket they fall into. And my experience has been that, you know, typically you've got three types of clients at that early stage. One is one that's very uninformed about the finances and the operations, really doesn't have a lot to tell you specifically about the things that you might care about as an expert dealing with the financial side of it. The second is somebody who's got a lot of information and, you know, may not fully understand it all, but has a lot of information and can fill in a lot of holes. And the third is someone sort of in the middle who maybe knows enough to feel angry and maybe has enough to sort of point you in the right direction, but maybe not explain it well. And so from my end, that initial discussion with the client is super important. Helps to understand whether the things that we should be asking for and talking about further relate to, you know, dividend policy or related party transactions, or the size of a potential valuation of their interest, if that's something that they're ultimately looking to have as a remedy. And so that initial discussion helps to focus, number one, on their understanding, but also then helps, I think, as a practical matter to target follow-up discovery requests or follow-up, you know, reviewing specific documents that they may have in their possession already. And obviously, you know, that's probably a good segue into, you know, thinking a little bit about the types of documents that you might want to ask for pre-litigation. And those types of documents, obviously, there's a statute that kind of lays out the easy ones. But frankly, the easy documents, the ones that are specifically authorized by statute, usually don't give you enough information to really understand enough to understand that whether the client has a great position or a weak position, or you just don't know. So those would be the, you know, the things I typically look for right out of the gates when trying to frame not only what I'm looking for, but also to help that client understand a little bit more about the battle they may be in for and the issues that they're going to have to deal with.
All right. Sound is low. We good? Take what down? Oh, yeah, you can take that down. Yeah. All right. Okay. Sorry about that. So litigators on the panel. Well, how do you feel about working with your expert earlier rather than later in this pre-filing phase of the case, and how it can help or possibly burden in some ways?
Hey, Mark, it's Bernie. I'll piggyback on Tom. I mean, the problem we sometimes have as lawyers and dealing with the clients is sometimes clients don't want to spend the money on an expert early on. They don't see the value, they penny pinch, and it's sometimes tough to get them to not pay just for your services, but also for an expert to come in. But if you take a 30,000-foot perspective on it and really talk with them and explain it to them, it oftentimes is money well spent. And really to piggyback on Tom, and for the law students out there, you know, you're walking into a case and you don't have the fact pattern yet. It's not given to you. You have to really create and understand the true fact pattern. So to Tom's point, you know, you really need to get in there and interview your client and find out the good, the bad, and the ugly. And sometimes I analogize it to really deposing your own client. They've called you for a reason, but they don't really know all the details. And you really got to press them on what they know, what they don't know, and where you're going with it. And on those three buckets, I mean, Mark, you and I had a case recently. You know, sometimes you'll have a client who has no idea what's going on, and you don't have the pieces to the puzzle or any pieces. But we've had experience recently where we had a client who knew the operations, knew the finances, and also happened to be an attorney. And he had a chronology ready to go. Everything was there. And even then, we had to dig into it more. And we were able to get this person to understand the benefits of bringing in a forensic accounting expert, someone like a Tom, to come in and analyze the documents that you have, the operating agreement, the buy-sell, the financials, and really give at least an initial opinion on what they think the value might be worth and what else you need to really further develop that. And, you know, a couple hours here and there is worth the expense, than getting a litigation started and ending up down 6 months down the road, with a done of a case. So I guess, Tom, from your expertise standpoint, how do you go about helping the attorney and really helping the client understand your value at the beginning as opposed to the middle or the end?
It's a good question. I think that from a personal perspective, I always, am frankly willing to spend a little time up front to try to help not only the attorney understand whether they have a case and potentially the value of that, but also to help that client, especially with regard to setting expectations. And so that initial conversation really, frankly, from my end, isn't about fees, because that really isn't, in my view, the driver. It's to try to go in with your eyes open. And I think more than anything, the types of issues that you can identify very early on almost always demonstrate value to a client who's about to embark on a process that is not only financially important to them, but also, as emotionally draining. Sometimes it can be a distraction if you're in business and you're not in the business of litigating. These kinds of cases take time. So I think the value add early on is actually very easy to demonstrate, because it helps the client to set some reasonable expectations, to understand some of the things that they're in for. Frankly, it's really important, in my view, in scenarios where you have a client who really is uninformed as to the nuances of the business. I'll give you an example. How many times have you seen a client come in and you ask them, for example, how many operating agreements are there? Or is there a shareholder agreement that you've signed? Or what sort of things govern the way that you interact with the rest of the shareholders? And they can't answer the question. They don't know, what their rights are fully. And I'm saying not just in a legal sense, but in a even broader, more practical sense. And so those initial conversations, whether it's with the attorney or with the individual client, very, very important to help them understand what they're getting into and what their, realistic options are going to be as the case progresses.
Guys, one of the issues that I see is, once litigation is commenced and once the hold letters are sent, there's an obligation and a duty to preserve certain information. But before that happens, there's an issue there, because that obligation doesn't exist under the court rules. And so there's always a risk of document destruction. Obviously, we can ask for documents pre-litigation under the statutes. And one of the questions that I think we're faced with is what kind of information do we need at a basic level for purposes of assessing the value of the company? And then also, what kinds of things that can be done early, perhaps upon demand, shareholder demand, to preserve information from a technical perspective? Computer imaging the computer, helping digital reproductions get made, that kind of thing. So Sean, if you could comment on that.
It's our clients, it's the best interest of our clients to seek preservation as soon as anticipation of litigation is coming. And so really, we work a lot pre-litigation, Mark, to your point, and we help clients identify all the sources of potential ESI that may be relevant. We at least try to get those under preservation right away. We might get them preserved and have them sit for months, years even. But at least we know that we've kind of covered and we froze that date and time. And so there's no issues of spoliation.
Are you seeing a trend in that happening earlier than later in cases?
Absolutely.
Oh, and what about at the pre-filing stage?
We're seeing it earlier and earlier, because I think the judges are becoming more educated on spoliation issues. There's more case law coming out. So I think that the clients and the attorneys are more informed and educated, and to the point that they want to protect themselves in their case.
Yeah. Can any of the attorneys on this panel comment on spoliation of evidence and adverse inferences that they might have seen arising, or or been faced with in this context? Bernie, RJ?
Well, I'm glad to say that I've never been subject to an adverse inference, but it's it's a
good
real
start.
it's a real rule, obviously, and I think Sean raises a very good point. I think the judiciary is becoming more and more aware of the technology that is in play that sort of, I would say, has changed the landscape to prevent this, I don't know, this kind of default explanation that, hey, I have a routine document destruction policy, and every 30 days, I completely wipe my servers. Now we have a pretty clearly communicated technology that a lot of judges know about to preserve the evidence. So why can't we, maintain the status quo very early on in the dispute, even before litigation, mirror image the flash drives or the other computer devices that actually have this information, so that when it's needed, it's there. But I have read opinions regarding adverse inferences for failure to preserve. And I think the solace there is that we now have technology, albeit at some cost, but it's getting more and more modest, to actually avoid that from becoming an issue as long as you take care of it on the front end.
So it sounds like you're saying, RJ, and I think this is a valid point, that it's not just a way for a litigant to get at somebody else's information, but it's also the way for a litigant or a fiduciary or a prospective litigant to actually preserve their evidence so that they don't run into a situation where, though the case may be weak against them, they find themselves fighting against adverse inferences, if I'm hearing you.
Yeah, absolutely. I mean, it's, hey, it wouldn't be the first time that a client may have lost information that you wish you had. So it can also serve as a universe of information for your case.
RJ, I'll piggyback on that real quick. I mean, I'm using it right now. I'll leave the names to the side, but I'm using it as a sword right now. I mean, we sent the classic demand letters, about a year and a half ago, 2 years ago, give us all these documents, and we added the one-liner in there, make sure you preserve all evidence. Certainly after the litigation started, we send litigation hold letters to our clients, and my assumption is the other side did the same as well. We should all be doing that as attorneys, whether you're a first year or a 30 year. And then now we've discovered that at a deposition, we had found out through discovery requests and productions that there was just a whole bunch of missing documents. And of course, it comes out at the deposition that the opponent went and actually just deleted a bunch of emails, and that you could see the other attorney's face kind of drop. It's the last situation any of us want to be in as attorneys if we're defending a case. But it's important. And now we're on the cusp. We've filed a motion for spoliation, and we're asking for adverse inferences, which include but aren't limited to that. Certainly all those emails that were deleted would have cut against and favored the oppression that we're seeking. So, so things like that, if your client's not doing it and you're not sending those things on, it comes into fruition. It can really hurt your case. And who knows what those emails would have said, right? RJ, I mean, who knows, right? But now we're on the cusp of potentially getting an adverse inference that who cares what they said? The adverse inference is there, and their case could be shot. So it's easy stuff you can do at the outset, but if you fail to do it or fail to remind your client, it can be bad stuff down the road.
And RJ, I'd throw this in there too. I don't know if you've seen this, but I think one of the other dynamics too is, especially at an early stage in the case, when you make the statement, preserve and protect the following types of documents or ESI, one of the, I think the valid questions that exist there is well, what are the issues that we need to sort of be looking for and protect information about? So for example, if there are related party transactions who have their own separate documents and emails and so forth, and you're not a shareholder in that entity, but they have information that may eventually be very relevant in the case. If that's not identified, upfront in a shareholder demand, that party receiving the notice may not really have been put fully on notice of what they need to preserve. So I think that dynamic of, what issues you think you're going to end up litigating from a liability perspective, important upfront to think about. And, I would also say from a valuation perspective, what's relevant to value is sometimes pretty wide. There's a pretty wide net as to what kind of documents you might ultimately have some interest in looking at. So I don't know if you've had any experience there with sort of trying to refine the scope of the hold notice, or if the broadest net is the best way to go.
Well, certainly, I would say I don't like a broad net because I think it gives an opportunity for plausible deniability. I mean, especially if the goal is one to preserve evidence and the backstop to that is an adverse inference or some other remedy to address non-preservation. I think you want to be, I think what I do is I create broad categories of items to preserve. And I also narrow within each category, here are examples of what needs to be preserved. I mean, I find identifying individuals' accounts, email accounts, to be particularly helpful. It completely eliminates any excuse that the person, wasn't aware that this person's communications, email accounts, Outlook, whatever, may be relevant to the claims. You've identified the name and ideally even the email account, and they lose any sort of shield that they might otherwise have with just a general boilerplate litigation hold letter. And it kind of interlocks with what we were talking about earlier, Tom, is in terms of, consulting both with the client and with your expert as early on in the process as possible, because you don't know what you don't know. And once you do those consultations, it allows you to make more refined litigation hold letters, along with discovery requests. So really, the answer to your question is both. I have a general broad litigation hold letter, but with specific instances of what needs to be preserved.
Got it.
And I guess I would just add, since we have a pause here, is obviously the contours.
At least I can see you talking. Yeah.
Mr. Joke.
Yeah, they did.
Oh, hold on. Sean just made a joke.
It was.
We were
so
on
good.
Mute. So
It was so good.
What was the joke?
Oh my gosh. No, I said, you talk about depositions. I mean, that's all we have going on in this office is, laptops that have remote depositions going. And so we've really had to really adapt our business as I'm sure all the attorneys have as well. But in particular, I mean, court reporters are going to the office. And so while remote depositions are not new in our practice, certainly the exchanging of exhibits has been new, and we've got a great workflow. We've really thought through the process of how to make it as normal of a process, right? Because the last thing you want to do, Mark, is give all your exhibits to the witness or opposing counsel prior to the deposition, right?
But it's hard to avoid if you're posting them on Zoom, right?
Exactly. Well, we've come up with a solution that allows our clients to give us the entire universe of documents they may or may not use. We create an index for them, and then in real time, we help them present the exhibits via the Zoom chat feature and the screen share feature. So, we've really had to adopt
So
our
you'll
business.
run it.
Yeah.
You'll run it.
Yeah.
Okay,
So we have exhibit technicians, Eric, who's running this presentation today. We have you know, 8, 10 other people that do this every day, all day. They're not all as techie as you, Mark, you know, so they don't all have a war room like Mark Rossman does, but yeah, we're making it work. And, you know, we've had to buy a lot more laptops. We've had to buy a lot more Zoom accounts. I mean, we have 20 some Zoom accounts. So, you know, our business is really propelled, and we're doing more business than we did prior to this, because I think the attorneys are starting to see it as a viable option as well.
Bernie and RJ, how have you guys been liking the remoteness of depositions and exhibits and documents and all of that?
I love it.
What do you like about it? Wearing your slippers while you depose somebody?
No. I wear my 3-piece suit still, but no,
On the bottom?
what's that?
The bottom of it? Like not a pair of shorts or jeans or something?
Not yet. Sometimes jeans and a blazer, but I'll tell you, I was very reluctant to do Zoom depositions and hearings initially, especially depositions, because of the introduction of exhibits. And I like to be across from the deponent, and I like to be able to handle the documentation while I'm doing the questioning. And I thought that it's a bit awkward to go, you know, through a file on a screen to do that. And I was really amazed at the agility of handling exhibits via Zoom. It is a little bit slower, but I'll tell you, one of my favorite things about electronic presentation of exhibits is I get to control what the deponent sees. And instead of having them go off and look at page number 17 or flip around and look at other exhibits and redirect and kind of commandeer control over my deposition, I'm in control more than I've ever been, in a sense, because I control what they're seeing at any given time on the screen. So, and of course, hey, it's nice not having to drive to downtown Detroit, you know, in rush hour traffic.
Well, if it keeps you in control, that's good, because there's nothing more dangerous than a lawyer in control, right? Or out of control, maybe. So Bernie, tell us, have you had any Zoom snafus, or you tried a case recently, right? In remotely?
I did. I mean, like
How'd it go?
it's basically forced adaption. Okay. We got through it. I think it was fairly successful. You know, we had to do the openings and the directs and the crosses and the closings and all that stuff via Zoom. And there were hiccups, to be sure, but you know, we got through it, and it wasn't as bad as I guess I expected it to be.
What do you wish you knew at the beginning that you know now from it?
Well, I mean, we were pretty darn prepared. I tend to over prepare. So we had all the exhibits ready to go, but you really have to be careful about what exhibits you're going to use, and making sure the court reporter or the defendant or the other side has the exhibit. So what I ended up doing, Mark, is I prepared a complete set of everything and hard copy mailed it to opposing counsel, to the witnesses, to the court reporter, just in case the share screen on the Zoom didn't work. I could simply have them, you know, turn to page exhibit 22 of the binder I've already sent you. And sure enough, we needed it, because, you know, the Zoom kind of cut out. The court reporter had issues. One time I couldn't share my screen, so it was an easy transition for them to actually take the physical book out, go to exhibit 22, turn to page 32 of exhibit 22, and use it right then and there, instead of actually having to share the screen. So a little bit mix of old school with the new school worked out well for me.
Yeah. What about in discovery? Have we seen the pandemic affect any of our discovery or practices in terms of timing, how we get documents, access to the courts, maybe on motions to compel? More efficient, less efficient, tricks of the trade? Anybody got any thoughts on that?
You know,
You're always waiting for documents from lawyers. How's it been going in the pandemic?
You know, for the most part, I would say, you know, most of what I'm getting anyways is electronic. So most is not coming through paper. I think, frankly, one of the things about that in particular, though, is that it's much harder to schedule a shareholder meeting that has substantive, you know, conversation and communication. I know that's one of the things that sometimes you may think about as part of a pre-litigation effort to either resolve a case or to figure out what you're going to put into your complaint. But, you know, that whole process of getting in front of the other shareholders and trying to hash things out, or at least get positions staked out, I think that's definitely been more complicated, frankly, for me, more so than looking at traditional discovery documents.
Let me pose a question. So it's initial disclosures versus document and discovery requests. Where do we fight for our information? Do we argue that the initial disclosures are insufficient and really make a press for documents and information at that stage? Or do we accept their initial disclosures and just kind of wander out into discovery and start issuing requests?
So Mark, I can speak to at least my experience. I think most of the folks that I've dealt with, everybody just kind of gets out their initial disclosures just to comply. And then it's back to discovery requests 101. People are still sending their requests out, even if it's duplicative, and the other side's doing the same thing. And the battles are being fought on kind of the first round of discovery requests still. I haven't seen anybody really press too hard on the initial disclosures because, I mean, candidly, I think people are just kind of checking the box on that and moving to what they know. Will that change? Maybe, as you know, the court rules are still new and people are still navigating those things. But I think a lot of folks, a lot of practitioners, I'll say myself included, are really going back to what we know, and that's really getting into the discovery that you send out.
What about the difference between the third party and the first party discovery? I have a strategy of going after what I call BBA, the bank, the bookkeeper, and the accountants, because I find there's a lot of plentiful information in there that might just for some strange reason not be in the defendant's files. And so if you get comments sort of on third party discovery practice, just in general, and also coordinating it in the pandemic, which I find to be somewhat difficult in dealing with service issues and that kind of thing.
Well, Mark, one thing to add on the prior topic. I mean, I agree that the initial disclosures are not. I don't think they're very helpful. They're just too generic. You know, some jurisdictions like California actually have specific disclosures required by subject matter. And I think if we had oppression disclosures, you know, disclosure requirements, particular to oppression claims, I think they would be much more productive and save actually a lot of costs. I mean, a lot of the information is repeat in most, you know, oppression cases. You don't have the same issues, but you have overlapping issues often. In terms of third party, and I would say, I think there is one substantive initial disclosure in oppression cases, and that's computation of damages. You know, for a plaintiff in particular, you have to do a computation of damages as part of your initial disclosures. I mean, you can come up with some explanations as to why those can't be, why that computation can't be done because of lack of information, for instance. I mean, that's a classic issue of a plaintiff in oppression case. I don't know exactly what my damages are because I've been frozen out of the business information that I need to calculate that. But certainly in some instances.
RJ, on that point of damages, I don't want to forget this, but would the valuate, I think there's a serious question as to whether the value of a company in a shareholder case actually is damages, and whether that would need to be included in there. Do you or maybe Tom have any thoughts on that, or whether that would fall within the sort of equitable relief that the court held existed in the Matagula case when it stripped the minority plaintiff of a jury trial? So really is the valuation component, which we talked about earlier, is that really damages that would need to be disclosed at that point?
Well, I mean, I don't know the answer exactly to that question, Mark. I was involved in Matagula and testified on the valuation issues in that case. And that, like, frankly, many others, there's almost no way to put together something that is reasonably well done at an initial stage on a value question for, in particular for a party who has limited access to anything more than a financial statement. Damages, to the extent that they're different from value, same issue. I mean, I think there's, you know, certainly some cases where you've got a narrow issue, a very, you know, specific thing that an informed plaintiff, let's say, might know about. that they can articulate, that you can measure in very discrete terms. But realistically, putting together a damages analysis, for example, on, let's say, related party transactions, or alternatively, a valuation analysis for an ownership interest, very difficult at that early stage. So it's going back to the comment I made at the beginning. It's great to have an ability to help your client understand scope and help them to understand the issues they're going to deal with. But to actually be able to quantify a lot of that stuff early on in an initial disclosure is not quite as bad as throwing darts, but close.
So Tom, if I want to speak freely with the expert on the case before the case gets started, and I'm not quite sure even if we're going to have a case, and I don't know if the expert will be a testifying expert, how do you structure those types of arrangements so that we can get open and candid written work product from our advisor, our expert in this situation, and not necessarily have to produce it in the initial disclosures or in discovery?
I mean, I think there's a lot of,
And
different
have the option to transition to a testifying expert.
Right. I mean, there certainly can be scenarios where you retain someone to function as a, what someone would call a consulting expert. Typically their work product is not discoverable up until some point in time, or maybe never, but that depends. And I think you see some creativity that happens in certain situations where, let's say, a firm will take one person that's an employee and call them the consulting expert, and then some other person that works one door over is the testifying expert. If it goes that far, I'm not sure if that necessarily is compliant with the rules. But anyway, I think that initial stage can be, sort of in that consulting expert role. And again, I think, frankly, everyone benefits by having some knowledge up front from someone who's got some perspective and some expertise with the financial side of the case. Whether that then translates into a difficulty down the road, if you give an initial consultation or initial set of perspectives, frankly, it's almost, like I said before, almost always colored by the limited information that you have at that stage, and it almost inevitably will change.
So RJ, once the case is up and running, what kind of, how do you determine your discovery strategy and your approach to these types of cases? Getting the documents you need, getting the testimony. Do you wait for all your documents before you take your testimony? Do you think getting people under oath quickly is beneficial? Broad observations, but I've done discovery against you, so I know you got a few tricks up your sleeve.
Oh, nothing too novel. I don't believe in cookie cutter approaches to discovery. Even if it's, an oppression case, I don't think cookie cutter, discovery works very well, because then you get cookie cutter responses. So I tend to like to do written discovery first, and the nature of the suspected alleged oppression is going to, I think, dictate or at least inform the nature of the discovery, just like in any other case. A freeze out oppression case is not going to be have the same discovery necessarily as an inadequate redemption price oppression case. And what I broadly, looking at discovery in an oppression case, I try to find the snapshots in time and the evidence that relate to snapshots in time when we're talking about financials or decision making. And I try to then look at, well, what is the video reel? What's the reel look like? Because when we're talking about unfair conduct, it's that sort of subjective term. I think you have to look at comparisons. It's not only whether a certain transaction or decision was fair for a particular shareholder at a particular instance in time, but how does that compare to how other shareholders were treated? How does that compare to shareholders who are family members? How does that compare to shareholders who are running the company or in the control group? And so I try to get the instances, the snapshots, and the discovery that pertains to it, as well as understanding the broader context and picture in which decision making is occurring, so that I can better ascertain what exactly happened here and best make my case. Now, I'm talking from the plaintiff side, and I guess because there's more meat on the bones there, the defense side is almost the inverse, right? Is it's hard to prove a negative. I did not oppress. I did treat them fairly, and I have a simple philosophy: the truth will set you free. I mean, if you want to have a defense in terms of how you proceeded or had a good business judgment that was exercised, you're going to provide this information.
All right, that's the warning sign that we have 90 seconds. So in that time, one issue we didn't touch on, but I thought we should, is the remedies that we seek in this case and how important it is to define them early on. Obviously, where there's buyout, but there's a whole host of other ones. So if anybody can comment on that, I think that'd be a nice way to close it out.
I can comment, Mark. I mean, I think this just brings us back to the beginning stage. We haven't filed a lawsuit. I think you need to ask your client, what do they want? It's a simple question, but sometimes we as attorneys maybe fail to ask it. You might have a great oppression case and it might be worth a lot, but the person you're speaking to might define victory as, I just want my dad, the majority owner, to keep me in the loop. So you really need to define and manage client expectations and find out what the client wants. And from there, your strategy, how you address it after the fact is kind of dictated.
All right, well, thank you very much, gentlemen. The wrap on the first roundtable, and the next one will be up in a couple of minutes.
Oh, that's a good song for a mediation session. Come together.
Please welcome our mediation panel with certified mediators Jonathan
Wonder if that was
Frank,
intentional.
David Hansma, and Bill Winston, with E. Powell Miller moderating. This roundtable focuses on mediation and negotiation strategies in business disputes. Again, please feel free to contribute to the conversation in the media chat box.
I think we're ready.
Great. I'm happy to start. I didn't know I had the green light. First, I want to thank Mark Rossman for putting this together. I've spent decades in the shareholder oppression space, and I know Mark Rossman is at the very top of our profession. I don't know of anybody more knowledgeable about shareholder oppression law, and really appreciate the hard work you did, Mark, to put this together. I'd like to start with just a few introductory comments about mediation and negotiating strategies. First, in my experience, and I have done, I'm sure, hundreds of mediations in Michigan, all over the country. And my experience is that mediation tends to be underappreciated and under-resourced, given how important it is. I mean, how many times have we all got a mediation summary late, or sometimes prepared our mediation summary late? I sure hope that that hasn't happened in my firm now in many years, because about, I'd say now 7 or 8 years ago, I remember calling a firm meeting and saying to everybody, we have to understand that mediation is one of the key events in the case. It's often outcome determinative. It often succeeds and settles cases. I've seen mediation successful on the first try when no one ever thought in a million years the case would settle. I've seen it take 6, 7 mediation attempts in some of my MDL class action cases, as many as a dozen mediation sessions before a case settled. And in my view, it needs to have the same importance as briefing a motion to dismiss or a motion for summary disposition. It's well worth intensive resources. And I think it's really important that when going into a mediation, everybody understands the interests of all the parties. You can't settle a case without appealing to the self-interest of your opponent. And it's very important to understand what your opponent's self-interest is. I've also learned that managing client expectations is vital to a successful mediation result in terms of whether the case settles or doesn't settle. And just as importantly, whether your client perceives you did a good job in obtaining the settlement. Without managing client expectations, you might obtain an outstanding result for your client, whether the defense or the plaintiff, but the client doesn't appreciate that it was a great result. So one of the practice pointers that I would offer is it's our policy before a mediation to bring the client in for an in-person meeting. Sometimes we bring experts in too. And the purpose for that is to make sure that the client has realistic expectations. And the way I like to define that is I view our job is to help the client understand as best we can and as best we can handicap it, what is the realistic best case that could be achieved in litigation, with emphasis on realistic, because there's lots of things that aren't realistic, as well as the realistic worst case. And if you define those goalposts, a reasonable expectation is to settle somewhere in between those goalposts. And I would say in my experience, 80% of the time, clients are too optimistic. And in those circumstances, really in all circumstances, I want my clients to make sure they read my opponent's mediation summary, that they understand it, they digest it, so that they don't walk into a mediation only reading our summary and having sky-high expectations. But what I've also learned is that 20% of the time, clients will have negative expectations. Maybe they are afraid of litigation, they don't understand the litigation process, and they're either too willing to settle for too much if they're a defendant, or too willing to take too little if they're the plaintiff. Both are obviously very serious problems. And I think it's important to understand the interests of our fine judges. I've never found a judge who said, whatever say, don't settle the case. I mean, their performance metric, it's not their job to get a good settlement for either party. Their job is to encourage a resolution of disputes. And so if it's a mediation where the judge is present, I always warn my clients that, of course, the judge is going to lean on you to settle the case. I urge you to rely on my judgment as to whether you should accept an offer or make a different offer. Same thing with mediators. Most mediators view their job as to settle the case, and they're going to put a lot of pressure on you to settle. I love that interest when I have a client with unrealistic expectations, but I worry about it when I have a client who might be a nervous Nelly. And I try to prepare those clients to understand that the mediator is, of course, going to push you towards settlement. That's what they view their performance metric as.
Howell?
Yes?
Howell, can I make a point on that too?
Of course.
When I mediate a case as the mediator, I like to talk to the attorneys before the mediation, just the attorneys, separately, one call with plaintiff's lawyer, one call with defendant's counsel, because I want to talk to them, not in front of anybody else, so that they can tell me those dynamics, right? What do I need to know to help settle this case? And in particular, what do I need to know about your client? It's not very helpful for you to come in and say, you need to tell my opponent that they're going to lose this motion and they're going to lose this issue and I'm going to prove this and I'm going to prove that and their case sucks. That's not entirely helpful. I mean, it's good to know those things, but what's more helpful is for you to say, here's the issues with my client. Here's the psychology with my client. Here is, where I think my client is going to be realistic, and here's where I think my client's going to be unrealistic. And, I need your help as the mediator to help my client see reality. And to your point that you were making, I think it's really good, Paul, that you have a meeting with your client to tell them, to discuss reality, because I think a lot of clients come in not having had the reality check. And as the mediator, no case is going to settle unless people see reality. But as the mediator, we don't want to embarrass counsel by being the first person to tell the client that their case isn't as strong as they think it is. But
And David, I agree with you in 80% of instances, but I found there's 20% of the time where I have a client who's got a great case, but they're not confident in their case. It's early on, and they're afraid of litigation, and they're too quick to want to give it away. And when in that kind of context, if you're the mediator, I'm going to be very, very guarded in that initial call with you, because it's my job to protect my client, sometimes from the mediator. Because the mediator is going to push my client to settle the case, because that's viewed as the performance metric when it's not in my client's best interest. And in that context, I'm working really hard to increase my client's confidence in their case and to have trust in me, not the mediator. Because the mediator's job, of course, is not to advocate for the client. That's our job. The mediator's job is to settle the case. So
that's good information for the mediator to have, because I would like to know going in, why is Powell treating this mediation like it's the trial? Why is he being so, pedal to the metal on the merits of his side? And knowing that you're doing that because your client is a little bit, willing to give up more than maybe he or she should. That's helpful information to have coming in, I think, as the media.
Yeah, I think also, Paul, the main thing, and I do the same thing David does, I'm sure Bill probably does too. You have that conversation, and I talk to you, Paul, and you say, I have a nervous Nelly. That's a good conversation for us to have, so that I know what your outlook is and what your client's outlook is. If you say to me, I have a client who's got the most crazy expectations about the value of this case, I haven't been able to talk to my client to get them off the ledge. They think it's worth so much, I'm going to need your help. That's good for me to know too. And what I do to help out during the mediation is I present to the clients the idea that your job, Powell, or any lawyer's job, you're wearing two hats ethically. One is you're a very zealous advocate, but you also have to give your client frank advice that may sound like you're not so much of an advocate. You're not the gladiator. And if they hear from me some things that maybe you wanted me to say, I think we work in tandem on those clients. And I think the pre-mediation call is an excellent way to find out where you think I can help you.
100% agree in most cases, but I'm talking about the exception. I have definitely had cases, sometimes representing an organization where there are some people who have a realistic appraisal of the case and some people who don't. Now, obviously, we follow our clients' directives, whatever that may be. It's their case. If they choose to settle it for less than it's worth or to pay more than they should, that's entirely up to them, not our job. But I have just learned from many years of experience that sometimes I have to protect my clients from very good mediators who are good at reading who is the weak person in the room, and then taking advantage of, and not in a bad way, I don't mean this pejoratively, don't misunderstand me, but I've seen very good mediators who view their performance metric as settlement, reading who's the weaker person, exploiting that and getting a settlement. And if I think that's not in the best interest of my client, I'm going to have a very open and honest conversation with my client before that mediation,
right?
So that they're within those goalposts.
Let me throw it over to Bill
Sure.
on that issue to be the tiebreaker. Not really, but still, because my sense is, Paul, that my job is to kind of pierce you a little bit, because maybe there's an interest your client really does have that is a like Bernie said, what is the client's real expectation? Do they want an apology from their dad? Maybe that's really what they want. And maybe the lawyer has been pushing them towards $1 million, and what they really want is just an apology from their dad.
Well, I think what this discussion shows is that one size does not fit all, and that you need to be flexible and to adapt with respect to a mediation. I think as a mediator, it is critical, particularly in the morning, that you hear each side out. You need to understand their position or grievance. You need to make sure that they get that you get their situation, that you're empathetic to their situation. You need to build trust. That's incredibly important for the morning. You need to be flexible how to proceed, as I said. You need to, on both sides, point out the uncertainties and the stuff that can happen during the litigation that could be harmful to each of them. And you need to understand the change in circumstance that typically has occurred that has caused the litigation. The oppression cases fit various patterns. Is it the original investor who was critical then, who now is getting paid a lot of money, but isn't contributing anything, and the people operating the company don't want to keep paying him? Is it a dispute between the original founder and the person who's grown the business? Is it a fight between siblings or generations of relatives? Is it a change over time in who's doing the work, but the shareholder agreement still has a kind of a fixed relationship? You have to figure that out. And then you got to change the dynamic. People come in with, or try to change the dynamic. People come in with some pretty set views as to outcomes or dollars involved, that kind of thing. And you have to do what you can to raise some things that they may not have fully internalized, that may cause them to view the case differently. For example, if you're the majority and you're alleged to have oppressed the minority, but you have a bank loan coming due, and you need the minority as a guarantor, and the bank's going to want the minority to re-up on the guarantee, you may not have the ability to finish the case because that minority is going to have a lot of leverage over you coming up. So you got to, look at those. That's just an example, but look at those kinds of things. And I think it's very important early on not to be too judgmental, to not embolden the intransigent, somebody who's relatively intransigent, and be relatively gentle with them in the beginning. Afternoon, there may be a lot more tough love. And I think it's very important to support the attorneys and to reinforce to each side that they have a good warrior for them. But here are some issues that you need to consider. I'm also not a big fan of exchanging offers too early. Both sides almost invariably are way too hard on those issues. What I prefer to do instead is, at least in the beginning, ask each side to confidentially tell me where they really want to end up, so I can figure out where the goalposts are. Obviously, they're not going to tell me 100% what that answer is, but I think that's much better than asking them for an offer. I don't communicate those goalposts to each side, but it helps me understand how to proceed going forward once I know how large the gulf is.
So,
Yeah.
Bill, I'm curious.
Bill, I gotta say, I completely agree with you. I've become stubborn about it. Lawyers will want me to pass along an offer. I know it's just going to inflame the other side. It's just going to. I mean, if they had an offer that was reasonable, they would have settled the case already. So my goal is to hear both of them and kind of digest what they say, and then figure out how I can explain it to each one. I'd be curious to know if any mediator or any lawyer who's done a mediation of a business case feels like it's a good idea to put a really hardline offer out on the table early on. I've never seen it work.
I would say not in an oppression case, certainly, maybe in something more straightforward like a breach of contract, but in a complicated case like a shareholder oppression case, especially, we call them business divorces, and the emotions are usually running about as high in a divorce case. And typically the opponents loathe one another. Any number that comes out at the beginning is just going to be seen as an insult, whatever it is, right? Because the emotions are running so high. And that actually, I wanted to get back to, just briefly, if I may, something Bill was talking about. At the beginning, as the mediator, I think another role the mediator has, because sometimes I'm not sure counsel, and I will confess to not doing this myself, always do a good job of getting their clients to buy into the mediation process. A lot of times they're there because they're ordered to be there by the court. They don't want to be there. They don't want to negotiate. Why should they have to give up anything? Why should they have to concede on anything? They're right. Their opponent's wrong on everything. This is a waste of time. And it's not that. It shouldn't be that. It's the party's opportunity to reach a business resolution of their case. And, you know, I think most of the time mediators are trying to get their clients or get the respective clients to see that and understand that. And like I said, I will confess, as a litigator representing clients, there have been times where, you know, I probably haven't done as good of a job as I should have getting my client to buy into that process before we show up at the mediation. And, you know, that's something that you then have to try and overcome in the morning of the mediation. And that's really not the best way to do it.
I think that goes back to the point about preparing your client. Powell, you mentioned, you know, managing your client's expectations. And I think it's important for the lawyers who are listening to this, who are representing clients that are about to go into a mediation, to really have a firm conversation with them to outline what it's going to look like, prepare their expectations. I would even suggest explaining the logistics, like what is the mediator going to say right away? Are they going to talk to you about confidentiality? Are they going to put you in separate rooms? How are the caucuses going to go? Because you have business people that aren't familiar with the process, and they need to be, it's like going to a doctor's office. If you can say to somebody that's about to go see a cancer doctor, when you show up, you're going to see the receptionist, you're going to see the doctor a little while later, maybe longer, et cetera. It puts the person at ease when they show up and it really happens that way. And I would suggest to any lawyer that's putting a client through mediation, talk to your client as much as possible about what the process looks like. It'll relax them. You need them to be relaxed.
So I'd like some thoughts on what people think are characteristics of a good mediator as compared to one that's not so good. In my experience, I have seen some wonderful mediators, and I would definitely put Bill Winston at the top of that list. And I've seen some mediators who are like considered famous mediators outstate, who I was extremely disappointed in. And so I think choosing the right mediator is very important for every case. So what should folks look for?
I think you have to have somebody who's a good listener, first and foremost. If you have somebody that's aggressive and feels like they can dominate as the mediator and tell everybody what to do and not be listening to the cues that you're getting from the participants, you're going to have a bad mediation. And it may be people you're talking about, Paul, that have a big profile or whatever, and you have to have your ego down as the mediator. I think that's the most important thing. You have to be able to take everybody's point of view and massage it and play it back and reflect it and see where you can bring people together and not dominate the conversation.
Yeah. I'm going to give an example of a bad one. I'm not going to mention the name, but it's a world famous mediator based in the DC, Virginia area. And what this mediator would do is comes in always with an assistant. So you're not just paying for him, you're paying for the assistant with 2 laptops. And whatever you say, you just hear these 2 laptops going for 10, 15 minutes. And all he does is then go to the next room and do the same thing and ultimately just exchange numbers. I have found that to be the worst mediator. The characteristic that I look for, I'd say, are 2 things. Listening, I agree with you 100% on that, John, but it's really understanding the case and rolling up their sleeves and knowing the strengths and weaknesses and being able to articulate those strengths and weaknesses and being determined. I mean, I am so appreciative of mediators when a case doesn't settle that will call a couple days later or a week later or sometimes a month later, because those mediators understand that sometimes sides stand on ceremony, excuse me. They don't want to appear weak, but a good mediator will stay involved. Bill, what do you think?
Well, I think that the key to success at a mediation, especially in a business divorce case like an oppression case, is each side has to feel that you get their case, you understand their case, their points have resonated with you, And because for them, this is their day in court, typically. And without undercutting that you understand it and you get it, you just need to point out things that they ought to take into account, which should cause them to focus on why it makes sense for them to buy out the other side or whatever the appropriate resolution is. And you need to get them there. And there are, frankly, incentives for the oppressor to buy out the oppressee. There are incentives for the person alleging oppression to get a check and go home. And you need to kind of focus on what the weaknesses are in their position without putting a dagger in their heart, but pointing out how it could all turn to manure for them. And therefore, what maybe you can get on the table for them is a lot better than the abyss of litigation and all the uncertainty that goes with that. So I think if you can establish credibility with them in the morning, by the afternoon when you're making these points, they're going to resonate with them. And you know, the vast bulk of these settle. And by the way, the nationally known mediator power that you have, I'm sure most mediations don't go one day because you can't get it done in one day.
You got that right, Bill.
Bill, the interesting thing about that is, how do you do that? I mean, the skill of being a mediator is to read the room, right? So you have to be perceptive enough to be able to say to somebody that feels bullied. Let's assume you have a minority in a family, they feel bullied, maybe since they were 5 years old, by the rest of their family. So how do you empower that person during the mediation to feel like, I get that, you feel bullied. This is your chance to be on equal footing with the rest of your family because you're in the court system. So you have some power. And then you say to the bully, listen, it seems like the problem you're having in this family dynamic is this brother, whatever, feels like they've been bullied by you. And I've put it directly out on the table because I think it's effective to acknowledge the kind of underlying source of tension. But you have to do it in a way that doesn't sound like you're scolding, right? That's the hard part.
So I have a negotiating strategy question, and our experienced mediators, I'm curious what your views are on this. Whatever number, say, a plaintiff gives, I'm sure you think that number is obviously inflated. How much do you discount it by? Is there a rule of thumb?
No, we'll let David start. We've been talking.
Go ahead, David.
I wouldn't say there's a rule of thumb. I think the more important piece of it is whoever makes the opening demand or opening offer, that the other party understands that it's just an opening, and that, you know, no one sitting in the room, including the person making the offer, really thinks that that's anywhere near what the case is going to settle for. So don't be put off by it. Somebody has to make the first move. This is what it is, and now let's go from there, rather than getting worked up by, you know, why is plaintiff's demand so high, or why is defendant's offer so low.
David makes a good point. Sometimes I'm the one that makes the first move. In other words, I have not exchanged offers, but I've listened to each room, have a better understanding of what their confidential positions are. And what I then do is bring the lawyers together, say to them, look, this is not going to be a surprise, but each side is very unrealistic in terms of what they think should happen here. I think if we're going to have a productive mediation, we need to get on a playing field that makes sense here, given the case. And I propose brackets. And you know, I say, you know, if both sides say yes to the brackets, we're going to continue. Anybody wants to reject the brackets, we get to go home. And you know, you have to be very creative on how you set the brackets, because you've got to set them where you narrow the dispute, but they're set also at a level where you have a reasonably good chance of getting both sides to say yes. There's an art to that. And of course, on the brackets, you have them each confidentially come back to you and give you their answer. And you only find out the other side's answer if you say yes. So nobody needs to worry about setting a new floor or ceiling. But brackets can be very useful if you have unrealistic expectations, because now, on both sides, because now, if they say yes to the brackets and the other side says no, the other side didn't know that they said yes. But if your brackets are reasonable, you've now moved it into a much better discussion.
You know what I've coupled with that is a kind of a cross-examination, and Bernie mentioned this in the last session, which is you have to be able as a lawyer to cross-examine your own client. And I think in an oppression case, especially where there's so many moving parts, the lawyers have to appreciate that we may cross-examine their client, we may need their help. And to follow your point, Bill, if you're going to do that and you find that the underlying foundation, the building block of a particular side's demand or offer is, and I just did one where there was an overcompensation issue by officers. Well, that became a fundamental issue in the mediation, and it turned out there were some misperceptions of the underlying facts and some of the expert testimony on that issue. Well, if I can cross-examine gently and say, hey, you know, you're really relying on this overcompensation issue, but did you consider maybe that your expert overlooked this? And now they're not really backing off of a position just arbitrarily. They may back off because they realize, uh-oh, that's right. We went too far on that point. But again, you have to be careful that you don't sound like you're coming in the room and blowing people up about it.
I'd like to raise one thing about virtual mediations, given the world we're in now, including virtual symposiums. I've done several virtual mediations over the last, during COVID, and there have been some, my observations are, my concerns with respect to virtual mediations have not panned out, but I had the wrong concerns. My concerns were that I would not be able to read people on a screen, and that I would not be able to build a rapport with people. Fortunately, both of those have proven untrue. I think you can read people on the screen, and I think you can build a rapport. What I did not expect, and what you have to account for, is that because it's virtual and people don't have to travel, you frequently get a lot more people on each side participating. And so you have more hawks maybe in the room than you might ordinarily have. And because you're not sitting in the room or across from the client and looking at the client when you ask a question, where it's clear the client's supposed to answer, I find the attorneys are much more active, or try to be much more active in the virtual mediations, and you have to find a way to defeat that. I apologize. And so, you know, sometimes it's, you know, Mr. Client, what do you think about this? As opposed to just saying, what about this? You need to make sure that you get the client talking as much as possible, and that the attorney doesn't front for him or her more than you want them to.
Just asked about creative tools that can be used in a mediation. One thing that I've done sometimes as a litigant is where both sides clearly have confidence in the mediator.
Oh, can you speak louder, please?
Yeah. When both sides have confidence in the mediator, but progress is not being made, suggests that if the mediation is not successful, the mediator becomes an arbitrator. And that does two things. One, now everybody better be reasonable, because now the mediator has the power over everybody, and that sometimes brings people closer together. And second, if everybody has confidence in the now arbitrator, even if you don't settle it, you hopefully have a faster path to resolution. Bill or David, you have any thoughts on that?
I have not done that specifically. I've done it where you do your, written settlement agreement at the mediation, and then where you agree that the mediator will arbitrate any disputes when it comes time to formalize that into a more formal document. If there's a dispute over, what did we really mean by this short memo of agreement? I've done it where, the mediator will arbitrate that issue and things like that. I've not done it where the mediator would arbitrate the merits of the case, which I think you certainly would have to have confidence in your mediator to do that. There's reasons judges don't get involved in settlement conferences where they're doing a bench trial, for example. So, you need to be careful, I think, as the advocate about, do I want this person who I've sort of disclosed the skeletons in my closet about my case to now decide my case?
Yeah, there's a lot written about that. And the real concern I have on both sides, either as an advocate or if somebody asked me to do it, is that once the mediator hears the settlement positions, it's like what you were saying, David, about a bench trial. So once the mediator hears the settlement positions, and now you're saying to the mediator, we couldn't work it out, so please arbitrate. Well, the natural human instinct is to find a number that you feel like you're not going to make anybody pissed off at you. So even if you in your head think, all right, I'm moving now from my mediator hat to my arbitrator hat, and I'll just look at the facts and everything like that, I think there is some of that underlying sense of making everybody satisfied. It's a it would be a challenge.
I think that's especially true in oppression cases, especially oppression cases that are being arbitrated. If you've got a case that goes all the way through trial, these people that hate each other in a business divorce, regardless of the relative legal merits, I think any arbitrator is going to be tempted to separate these people, regardless of whether or not the conduct really meets the technical definition of oppression. We've just got to get these people apart. I think there's a
no fault divorce proposition.
Yeah, exactly. And so I think, and that's something that you can use as an attorney when you're representing a client, is to, especially if it's in an arbitration context. I think there's less risk in court, probably more in arbitration of this. If you're representing the defendant, you can tell them, look, there's a lot of risk here that regardless of the relative legal merits, the arbitrator is just going to want to separate you people, and you're going to be buying your partner out. And when you're representing the plaintiff, you can kind of give them the reverse of that. You know, the arbitrator is going to be tempted to just separate you, but the price you're going to pay for that is you're not going to get the number you think you're going to get. And so you both have risk.
Again, I think the whole key is, finding common ground any way you can. I'll never forget one I had, big case where Tom McNeil was my opponent, excellent lawyer. We had, I guess that when I said the guy in DC was the worst mediator, this guy probably beats him, based in New York. And we were at 3 expensive mediation sessions going nowhere, going backwards. And on a hunch, I called up Tom and I said, Tom, this is an unusual mediation. The mediator keeps telling my client how great his case is. I got a hunch that he might be saying the same thing to your client. He said, he sure is. I was like, oh my God. So we both agreed to discharge the mediator. That was our common ground. And Tom and I sat down and figured out a way to settle the case. So.
Let me just jump on something Bill said, because I think it's a wave of the future in terms of Zoom. I agree with everything Bill said in terms of my fear that and not being able to read the room, but you can do it and you can establish a rapport. There's a big value in what's called asynchronous mediation, which is I can have people sitting in their office from 9 to 10. They don't have to come to my office. They don't have to sit there all day. I can go to the other side from 11 to 12, and they don't have to be sitting waiting for me between 9 and 10. And then I can say, you break for lunch, but not the other side. I'm going to talk to the other side while you break for lunch. And there's a huge advantage to doing these by Zoom. I'm still going to spend the full day, but the parties, especially business people, can sit in their offices. They can get some work done. They know that I'll text their lawyer and say, all right, come back on the call in 10 minutes or 5 minutes. And they don't have to be wasting a whole day. And I think that's something that even without the pandemic, I think we ought to consider doing.
And I do think that even if it's a virtual mediation, especially in an oppression case, it is very important to see if you can create a binding term sheet that people sign by the end of the session. What I typically do is while the session's going on, I'm working on a term sheet. Obviously, it has some blanks in there. But and it says at the end that it's a binding, and while the parties may contemplate a more comprehensive settlement agreement, this term sheet is binding and enforceable without regard to whether they ever enter into that, so that there's a deal, because these people have been fighting, and it can all fall apart if you let them leave the
don't let them leave
the ambiance of the mediation. So yeah, another thing you can do to change the dynamic, given the recent Court of Appeals decision in Michigan, is discounting of fair market value is now in play. So from the oppressor standpoint, from the plaintiff standpoint, that person's at risk that they're going to get substantially discounted because it's a privately held company with no market. And so, and then the oppressor can turn around and sell the company the next day and make the spread. The contrary is true with respect to the oppressor. They may end up paying full freight market value as determined by Tom Frazee in his very aggressive analysis of what the market value is. So they're really, the benefit for the oppressor in settling it is if he can get a price he can live with, and maybe even that price is not very far off from what he's been paying the person every year. And he's just spreading it, you know, and he's taking the money he would have been paying him and cashing them out. So, you know, there are lots of benefits to doing such a deal.
Does music mean we're supposed to be done? Is that what that means?
It's like the Academy Awards, David. I think that means they're taking a commercial break.
Yeah, I think we passed the baton now. Thanks,
All right.
David, Bill, and John.
Thank you, everyone.
Great job.
Our next panel will start momentarily. And now for our last roundtable discussion of the night, please welcome Norman Ankers, John Below, E. Powell Miller, H. Joel Newman, Ian Williamson, and moderator Bernie Fuse. This roundtable focuses on trial preparation and trial strategies. And so without further ado, Bernie, take it away.
Thank you. Thank you. And I got to tell you, I love that voice. I wish I could steal that for all of my Zoom meetings going forward. So I'll have to do some recon after this and figure it out. Well, welcome everyone. We are now at the trial prep and trial stage. And let's just kind of set the table. Our mediators have failed miserably. So Bill, John, David, you guys did your darndest, but you couldn't get it done. The motions for summary failed, and we are on our way to trial. So just in terms of a quick roadmap, obviously, we've got a great panel with us today. We're going to get into about 4 or 5 little areas and certainly mix it up. I will monitor the chat, so if anybody has any questions, I will monitor that and pose them to our esteemed panel. We're going to get into the theme and theory of the case to start with. We'll also get into opening statements, what you should be doing, what you shouldn't be doing. We'll certainly get into witnesses, obviously the direct and cross examinations, and maybe how COVID and virtual examinations may have changed the game, or maybe they haven't changed the game. And then of course, we'll talk about jury and bench trials, certainly in the age of COVID, but also taking into consideration, the cases in terms of what does go to a judge and what does, or what could go to a jury. And then again, I'll try to mix in some Q&A and try to pose some questions in the chat. So please feel free to put finger to keyboard. So let's go back to theory of the case. So Joel, I'm going to start with you. To our law students out there, and certainly the law professors, you always want to get into talking about your theory of the case. And typically what we hear, Joel, is you should really be thinking and setting the theory of your case, the theme of your case, from day one. You've done your client interview, you're trying to get the facts of the case, and every professor galore typically says, really articulate and think about your theme of the case at the beginning. Well, now we're at the trial stage, and let me ask you this. Are you sticking with the same theme, the same theory that you started out with a year or two before, or are you changing the game? Where's your mind at as we go to day one of trial?
Thanks, Bernie. You're clearly sticking with the same legal theories that you've been litigating, that you've had motion practice about and so forth, but trial themes can still support these theories and be different than what you've been litigating in motion practice or in discovery in terms of personal relationships of the parties, especially family types of issues and other things which can present powerful evidence in terms of the dynamics of the case. The story has to be told by witnesses, and the witnesses, you might not have the witnesses to really tell the story you want to. As Tom Frazee mentioned, frequently plaintiffs who don't work in the company, individual plaintiffs who don't work in the company, have little personal knowledge about their claims or the operation of the company. Sometimes they can talk about family history, company history, what they get out of the company, what they don't get. And the judge and jury have to see them and they have to like them, in my opinion. Individual defendants are much more likely to have knowledge of the operations and the relevant facts of the company. And it's easier to get for them to tell a story, I think, than it is for some of the plaintiffs. The Bax, I was involved in the Bax versus Maroon case. And in that case, it involved claims of usurpation and freeze out. It was litigated for several years before trial, but when we got to trial, the plaintiff's counsel, Steve Sussman, told the jury in his opening statement, this case is about the role of women in the boardroom, and asserted that plaintiffs had been frozen out of management because of their gender. It was a complete surprise. It was something that had never been litigated. All we'd been doing is numbers on the usurpation, whether the self-dealing was fair, all those kinds of things up until then. Norman Lippett gave the opening statement for the defendants, and Norman read the story of the Little Red Hen, which hopefully everybody's familiar with. He even had the book with him, the Golden Book, Fairy Tale, the Little Red Hen, and he showed the pictures to the jury. You know, Maddie did this, where were you, Florence? When he wanted your help, where were you? Where were you? None of it had anything really to do with the legal theories of the case. In the end, the trial went for 12 weeks, included volumes of testimony about family dynamics, the theories that the plaintiffs should have stepped into management of the company, the counter theory they should have tried working there. Took up weeks of testimony. Even the issue of dad buying son a new car and not buying daughters one was part of this trial. I can't, Judge Templin came out of retirement to preside over that trial, and it settled after 12 weeks. We never got a verdict. But it was interesting, and it was only a small portion of the trial that was really about the case itself in strict terms. The parties in Maroon used mock jurors and mock trials to develop their themes, and I always do mock trials in a case that warrants it. I have found them very helpful in selecting themes and sub-themes. I tried a case in 2012 against several other participants here tonight, and the allegations against my client were self-dealing, usurpation, and of corporate opportunities. I did 2 mock trials. I went to the American Settlement Center, which has a really good setup. They provide the jurors, they feed them, they pay them. We do our presentation, then the jurors divided each time into 3 panels, went into separate rooms that were all videoed. We could watch them live, we could review the tapes. I lost the first trial. I made some adjustments based on what seemed to work with the jury and what didn't. In the second trial, second mock trial, we did a couple things differently. We laughed off one document that was pretty harmful to our clients. We just kind of ignored it, and that seemed to work better. We also developed a theme that the plaintiff had just completely disappeared and everything was his fault, everything that had gone on, because he hadn't been paying attention. He'd be getting notices, he'd be getting different kinds of information. He just hadn't looked at it and hadn't done anything with it. And we went to trial. I can't tell you how the trial came out because it settled. before verdict. But at the trial, the plaintiff spent a lot of time defending where he was. It became a big theme in the trial, and I think it affected the way the judge and the jury thought about the case. Like I said, I can't tell you how it came out because we settled at the close of plaintiff's proofs. Mark Rossman thinks he won. Ian Williamson thinks he won. And so do I. Think I kicked their butts. But I think Linda Watson is going to testify about telling a story in the trial, and she'll pick up on that. Some other people are going to talk about specific witnesses. But the theme has to fit what you have to present, and you don't always have the witnesses to do it. It also has to have some humanity to it, something besides just the ledgers and P&Ls and balance sheets and things that might be the crux of your real evidence in the case.
Well, let me pick on that point actually and rope in John Belo. You talk about humanity, and obviously we're in a what's the best word? A very heightened sensitivity in our current political climate, so to speak, right? There was a big event last week. I forgot what it was. It turned into a whole week. But John, I guess, let me ask you this. Do you think, potential cultural or political changes play into kind of your theory of the case and how you present a trial?
Yeah, thank you, Bernie. Thank you guys, all of you. I've always looked at like Joel, I agree, the theories of the case, they are what they are. Theme or storytelling is something that you can formulate early on in the process. However, I feel that it's more important to have a commitment to flexibility in that regard. And sometimes that can involve things that change during the life of the case or even during the trial. I had the privilege, or I suppose, to try a case during one of the hottest times for the Me Too movement. And I think many on this panel would know that I do a lot of employment related stuff. But the same arguments apply in an oppression case, which everyone I've done has a big employment contract involved too, typically, or often anyway. But, cases are about people and why people do what they do. So when you're looking at a theme or changing a theme, you have to simply take the theme that you think might resonate with people, because they're going to understand that and hold on to it a hell of a lot more than the data and the accounting and the elements of corporate law that might be thrown at a jury. So I think that the flexibility of a theme, either in trying to touch on a political climate change or a movement where people are in a widespread manner changing or breaking their silence about a topic like the Me Too movement, where they feel empowered to view facts perhaps differently than they used to, is all very important. You maintain the flexibility. Furthermore, in picking a jury, people are going to be more open about talking about their experiences when they're relatively in the throe of some type of cultural movement, which I think is quite helpful. They're going to be more open with you about their biases, particularly in my situation, a gender bias. But at the same time, I think people are just as likely, jurors or witnesses, to be assigned some type of bias because of a cultural movement that they've never had. So I look at optics. I'm always willing to adjust the flow and the marshaling of the evidence of my cases according to optics, particularly with a jury, but also with a judge. It has to be authentic, but how it's displayed, how it's rolled out requires flexibility. It requires attention to optics, and so forth.
I would say with optics, John, certainly sometimes maybe a Wayne County jury might be different than a Macomb County jury. I assume you're looking at that makeup and the people in the jury room and who you're picking as it plays into your potential use of.
I think it comes down to that, and I think it it's even more micro than that. It comes down to each individual in front of you. And obviously you can't address every individual and how they might interpret your case. But again, the optics they can be more powerful than the actual evidence. Because, like Joel said, we had a bad document, we kind of laughed it off. Well, if you can laugh, you can laugh it off if the audience is buying into a storyline that's bigger than the facts that you're presenting. And a lot of times the political climate or a cultural movement is going to carry that type of interpretation.
Right. Let me rope in Powell. This kind of goes to, we've gone through that. We've picked the jury. It's opening statement time. How are you approaching opening statement, especially these days? And maybe how does that play into kind of the closing statement and how you're putting on witnesses?
I think the opening statement is one of the most underrated parts of trial practice. I have a policy in my firm that the opening statement should be game ready 1 month before trial. And whoever is lead counsel for that trial does a complete opening statement in front of everybody in the firm who's available. Other lawyers, staff people, with lots of visual aids. I'm a big believer in visual aids. I was lucky 11 years ago to find a kid out of high school who anything you asked him to create, he's like instant Hollywood. I've had trials where the first thing the juror said was, "Loved your visuals." That helped me understand the case. And it's all thanks to this kid who's been with me since high school. So it's a very painful process because, we get invested in our case and very good lawyers do the opening statement. It always happens. 3 people will say, "Powell, I love that point you made there." And then someone else will say, "I think that's the worst point that you made in your opening statement." And you got to have a strong ego to handle the criticism. But what I found is by doing that a full month before the trial, you have really time to take into account other people's ideas who are not as close to the case. And the other reason why I do it that way is the opening statement is the cookbook. That's what we're going to prove to win the case. So everything flows from the opening statement. If you've thought through the opening statement, that's the roadmap you're given to the jury. And then what I like to do in closing argument is show the jury that we proved everything we said we would prove, but more. So I'm very conservative in the opening statement. And in my experience in virtually every trial I've ever done, my opponent overstates in their opening statement, and it makes for a wonderful contrast.
I guess let me ask you about those visuals. Any particular visual you find has worked the best? Are you bringing out the old poster boards?
Oh, no, not rare. Well, sometimes I'll have a poster board just to break it up, like a key contract provision on a poster board on an easel that I'll keep referring to. But let me give you an example. This is public information. The Carmanis arbitration, all confidentiality was waived. This kid I hired, I said, "Can you create a visual that appears that sharks are going around the CompuWare building in Detroit?" And he did. It was so cool. Sharks going right around the building. And I said, "Well, can you make it also look like they're going around Peter Carmanis inside the building?" and he did that as well. And 3 days into the arbitration, the arbitrator asked a question. I said, "I have a question about those hedge fund sharks," and just did a circle, just like the visual was. I've taken, another thing we did in that case, which was a lot of fun, is to take a cut from a Casablanca movie. Because one of our themes in the case was that Pete Carmanis was fired for who he is. And that he had, this was a case where he was alleged to have been disparaging of CompuWare management. Our theory was that I'm shocked, there's gambling going on here. So we took the clip from Casablanca where Louis shuts down the gambling house and says, and Rick says, "What are you shutting me down for, Louis?" And Louis says, I'm shocked, there's gambling going on here." And then there's a freeze frame. "Here's your share of the winnings," to the cop, Louis, and he's got this smug look on his face, holding the envelope full of money. Well, that was one of the key themes in our case, is they fired him for being himself. Then they stole the golden parachutes for themselves, and they were Louis from Casablanca holding on to the money. And it just makes things a lot more interesting. And in that case, my opponent never saw this happen before, said, I pass on opening statement, didn't try to counter it. And so I think an opening statement, when you put a lot of resources into it and you make it very interesting and exciting, can put the other side on their heels. And instead of starting on the 25-yard line, you're starting on the 50-yard line.
Yeah, no, I think especially in this day and age too, with people's attention spans aren't what they used to be, so to speak. That's just how social media and the entertainment industry has done it. So baking that in and catching the attention and putting it in somebody's mind is helpful. I want to rope in Ian Williamson. Ian, all right, let's say we're done with the opening statements. It's game time. We're putting out our case. You're doing the directs. You're doing the crosses. And now we're in the COVID arena. Some of us, like myself, have had to try the case virtually now. But I guess, how are you typically approaching your witnesses from a direct and cross perspective, generally speaking, and then maybe virtually if you've had to do that, how you've approached it? Ian, are you there? Maybe you're on mute.
Can't hear you.
There you I see you. You got a great gray suit, beautiful tie, but I can't hear you yet. No, not yet. All right, well, while you figure that out, John, I'm going to rope you back in, John Belo. Again, Ian's going to get into kind of direct and crosses and things like that.
Yeah.
Anything you got from a COVID perspective and a virtual perspective, and how you?
Yeah, again, I do a lot of employment related stuff, and the COVID-19 crisis, pandemic, what you want to call it, has kept me and my partners very busy. How it impacts, I think, this particular area is that communication in general, I think, has suffered significantly during the pandemic. And I think communication is so important to shareholder relations, minority shareholders, what have you, as well as executives. It's been a time where I've had the opportunity to work with clients who have longtime contributors disappearing from the active participation in the company. Sometimes it's because they want to isolate due to the pandemic. Some of these people are of a more mature age, if you will. And some of those folks are they don't really want to be out doing a lot of the things that we used to do and many people still do. And there's some isolation, and when isolation comes in relative to how you're managing your business, that breeds misunderstanding among and between partners, which I think can cause some really bad decisions financially for a company. I've seen this play out a number of times over the last several months. And while we haven't had any litigation yet, precisely because of this issue, I think that it requires businesses to place a premium on active, regular communication to maintain some type of shareholder harmony, if that's somebody's intended goal. Regarding executive employment agreements that can come into play in these oppression cases, we have issues with respect to executives declaring perhaps a good cause separation because they're working remotely as opposed to where they were supposed to work, or a location where they were supposed to work, as identified in their agreements as part of the good reason definition for their declaring or resigning from employment. So you have issues regarding remote work, you have leadership communication issues tied to it. We have return to work issues, IT issues, and, you know, concerns and policies regarding general health and well-being of employees, all of which can play into either the value of the business or the feeling of isolation, even among the highest level of a company.
Yeah. So let's, I think Ian's still having some issues from a technology standpoint, and that's okay. Welcome to the new virtual world. Norm, are you with us?
I am.
All right, Norm, let's talk about jury versus bench trial. All right, so obviously the position out there is, you know, oppression cases, you know, don't go to the jury, but a lot of folks have claims and they want to bifurcate it. Why don't you just talk to us about jury versus bench trials, what you're looking at, where you're looking to go, and, you know, maybe has COVID kind of changed your mind in terms of how you approach jury versus bench trials?
So I'm a great fan of the jury system. I've been an apologist for the jury system for the 41 years that I've been practicing. I happen to think that the jury is the smartest collective organism that American jurisprudence has ever created. And as those of us, and I know there are many of us who are jury lawyers who are listening in today know, you may take an individual person who's on the jury panel who doesn't know this or that, but if you put 6 jurors and 2 alternates into a room together in a case, that is one extremely smart organism that doesn't miss a trick. And I think the juries tend to get it right most of the time. Where they get it wrong is where we don't provide them with a sufficient amount of guidance with respect to damages. That's when you have runaway juries. And I think that that's our fault because the instructions aren't good enough or the legal constraints aren't good enough. So if I'm in a shareholder oppression case, whether I am representing either the ostensible oppressors or the ostensible oppressees, I'm looking for a jury trial. We know that under Madugula versus Taub, you don't get a jury trial with respect to the shareholder oppression claim, but we also know that there are always pendant state, there are related state claims which you can file, the most significant of which is breach of fiduciary duty. You know, there's also tortious interference and sometimes fraud and maybe breach of contract, but you have enough of a hook that you can have a jury. What I do in those cases is I push to have the jury make the decision first. The jury, and I ask the judge to have the jury function in an advisory capacity for purposes of the oppression claim, which the court is entitled to do. And then, of course, the jury is entitled to deliberate and to reach a verdict with respect to the fiduciary duty claims and related common law claims. Obviously, COVID has changed that dynamic from the standpoint that we're not having jury trials these days. And I don't think we should have jury trials these days in civil cases. I think that it is possible to have bench Zoom trials. I think there are challenges associated with that. But if you can't do a jury trial because of what's going on with respect to COVID in this kind of a case, whether I'm representing a plaintiff or a defendant, unless I have some really, really focused reason for wanting to get something done sooner and to just have a call one way or the other, I'm looking for a continuance.
Makes sense. Looks like we got Ian back. Ian, I guess I'll ask you 2 questions at the risk of being unfair. Anything you want to kind of add to Norm in terms of trial, maybe voir dire? How are you approaching voir dire? I mean, the selection of the jury is almost just as important as the jury itself, obviously. And then maybe go back into the witnesses, that I know you wanted to talk about witnesses and how you approach that as well.
Well, first, let's see if you can hear me, Bernie. Can you hear me?
I can hear you. Yep.
I'm going to get big on the screen like the rest of you, but at least you can hear what I'm saying. You know, piggybacking on what Norm was just saying about the jury or the bench trials, I'll tell you that because of the fact that we're doing trials virtually at this point, I am glad that I am practicing in this specific field and that I'm handling a lot of corporate and member oppression cases, because these are being tried to a bench for the most part, no matter what. Most of these cases that I am seeing go to trial, they're not going to trial with a slew of other claims, or if they are going to trial with other claims, they're going to trial with fiduciary claims, and people are agreeing to try these cases to the bench and not to a jury. I would not want to be doing a trial over a medium like Zoom and trying a case to a jury. I don't know anyone that I think would find that to be particularly effective. And in part, it's because when you are putting your witnesses on, I mean, going back to what Joel and John were talking about earlier in this roundtable, it's really about the people. It's about getting your witnesses to connect with the fact finders. The fact finders, as Joel said, the fact finder has to like them if they're your witnesses, because if the fact finder likes them and connects with them, the fact finder is more likely to think they're sincere, to find that they're believable. When it comes to my opposing witnesses, I want to either demonstrate that they're less trustworthy, which is easier to do for a jury, I think, when I'm in the same room with them. And if they are trustworthy, which, you know, oftentimes they are, at the very least, I want to be able to force them to undercut their own cases with some admissions. And then with the experts, of course, I want the fact finder to feel that my experts are more reliable than the other side's experts. Again, with the jury, I think this is easier to do if you can have them in the same room. Having business courts and having business court judges, I think, is making the prospect of virtual trials much easier because we have judges that are trying these cases that often have a business law background. Even if they don't, we have judges that, particularly if they've been on the business court for even a year or two, they've tried or they've seen a lot of these cases proceed. They've seen the expert witnesses talking about similar types of issues. They've seen parties making similar types of claims. They have a better understanding of the law. They have a better understanding of how these cases unfold. And I think it makes it easier to try the case to them. And as you mentioned earlier, people's attention spans aren't what they used to be. I think that's doubly true when you got people looking at a screen. I'm frankly amazed that we're several hours into this and that we still have all these people that are participating and paying attention tonight. Right. But we do. But, you know, this, I think, would make it even more difficult to try a case to a jury in a virtual setting because people's attention is going to wander. I think what that means for us trying cases, though, is that direct examinations, whenever possible, need to be even more crisp than usual. I say this, I know there are probably judges watching that are laughing to hear me say this, that I've tried cases in front of, but that is actually the goal. We want the direct exam to be more crisp. I think this is particularly true for experts. You've got financial details, you've got technical testimony that can cause fact finders' attention to wander quickly if it's not presented in a way that's clear, concise, and easy to understand. Again, trying these cases to a business court judge makes that easier because often they have the background where they are going to be able to understand what your expert is talking about, and you can really shorten the testimony that you might otherwise have to bring out to educate the fact finder on what the expert is trying to show. It's helpful to know your audience. If you get a good understanding of your judge's background, you know that the judge maybe has tried commercial cases for 15 years before they became a judge, that they've been a business court judge for 6 years. I think that tells you that when you're presenting expert testimony, you probably can be a lot more crisp than you might otherwise be. I think for doing your examinations, regardless of which witness you're going for, it is important to really try to hammer out evidentiary issues, especially when it comes to exhibits, as early as you can, so that you're not trying to deal with these while you're putting on testimony, so your witnesses aren't being constantly interrupted. Some people have talked about using a hard copy exhibit binders instead of trying to put things up on the screen. My experience in arbitrations and trials that I've done virtually has been, it is much easier if everyone has a hard copy of the exhibit and you're not trying to have people read off of a screen. I think the judges in any setting are going to be appreciative if you can stipulate as much as possible to what's going to be admissible before you actually start the trial, so you don't have to then go through lengthy testimony establishing foundations, deciding whether or not the foundation is sufficient, arguing about whether or not the document is going to be admitted. To the extent that you have all of that done or much of that done beforehand, it's going to be a much smoother process. And when you're doing the process basically over a screen, it's going to be much less likely that you're going to completely lose your finder of fact. I have had technical issues in arbitrations and trials that I've done virtually. Every single one of them has had at least some technical issue. So the parties and the witnesses having binders with exhibits in front of them that they can look at, and the fact finders having binders with exhibits in front of them that they can look at, has really made that much easier. I think objections can be a little more difficult to handle virtually than they can in a regular courtroom setting. Your body language in a regular courtroom setting, I think, is easier for the judge to read. It's easier for the judge to tell if you're about to stand up, if you're about to say something. It's also easier, I think, to cut off a witness that's testifying midstream if you need to make the objection. If you're trying to do it in a Zoom setting, it's much more likely, in my experience, that the witness will just keep talking for a while. They're not fully understanding what's going on, and it's not as easy for you to telegraph to the judge that you need to do something, that you need to make that objection. So that's something that I think you got to be a little bit more prepared for going in. Maybe make your objections a little bit earlier. Having your and anticipating what the objections are going to be to your own testimony as well. If you're up against someone, you know, we recently were in a trial against Norm. Norm is a very educated individual when it comes to evidence. He's a professor of evidence at University of Michigan. Going into that trial setting, I knew that if I wasn't anticipating what his objections were going to be, I was going to get hammered. So I actually wrote out my arguments for every single objection that I thought I was going to draw, and then just inserted it right into my outline. So I had my reasons there, I had my legal authority there, so I could pull that out as soon as the objection was raised. So in that sense, knowing your opponent's strengths is definitely helpful. On cross, I do think that it's a little more difficult to read your witness's demeanor when you're doing it in a virtual setting. At the same time, you know, Bill Winston was saying earlier that he felt like you are still able to kind of create that rapport with people through a virtual medium. I agree with that to an extent, but it is, you don't quite get the same level of detail, which I think makes cross a little bit more difficult. In order to try to counteract that, when I'm doing a trial or an arbitration, I actually project my computer screen onto a very large TV screen so I can see more easily what the people's body language is when I'm doing the examination. I find that to be helpful. And as I said, the witnesses are more likely to keep talking. It can be more difficult to determine when they're finished answering the question, and I find that people are stepping on each other a little bit more often when you're doing cross-examination in a virtual setting. You don't want to cut the witness off. I mean, you don't want to look less credible as an attorney. You don't want to look like you're bullying. You don't want to make them look more sympathetic. But at the same time, you also don't want to let the witness just meander. So it can be, I think, a tougher call to decide when the time is right to move in with your next question if you're doing the cross-examination virtually. You know, in general, trials are all unpredictable in some respects. I think that the same traditional challenges are still there in the virtual setting, but I'd still rather do it than wait, especially if I'm going to be trying the case to a judge in any event.
Yeah, excellent. Let's do some quick, we only got 2 minutes probably, so I think we'll start hearing the music real quick. Powell, let's do a quick rapid fire question. Someone just posed a question. How can you include such videos in trial? Aren't those videos that you're making prejudicial, non-probative? What's your response to that?
Well, the video that I did was in arbitration, which was more liberal. But in trial, we use a lot of graphics. For example, in a very complex securities lending trial I had in Minnesota, we had a highway sign. It was a highway, and it was a highway sign that said risky road, turn right, or left, safety street. And that was our whole theme of the case, that the bank always turned on risky road when it was supposed to stay on safety street. And we had that vetted by 2 mock jurors. And that one demonstrative, that one page, really helped them understand it. It was clear, it was simple, it was interesting.
Gotcha. All right. Well, thanks to the rest of the panel. I really appreciate you guys. Given Ian's technical issues, I hereby declare a mistrial, but I do order all of you guys to pay me my attorney's fees for moderating this. So, thank you guys very much. Appreciate it.
Please welcome Professor Douglas Mall from the University of Houston Law School for a big picture discussion of corporate oppression principles and their application. This is Professor's second time presenting at the symposium. Professor Mall, the mic is yours.
Can y'all hear me? Oh, there we go. Okay, sorry about that. Thank you very much for the introduction. I've been a law professor at the University of Houston since 1997, and much of my scholarship has focused on minority owner rights in closely held businesses and the related doctrine of shareholder oppression. And as I'm sure everybody who's here knows, Michigan has had an explosion of these oppression cases over the past several years, both in the corporation and in the LLC. And so I was very happy when last year Mark reached out to me to participate, and I wish I could be there again in person, but as we all know, that's sort of a little dicey these days. But I'm glad to be back to participate. My role here, as I understand it, is I want to go over some basics of the closely held corporation and the oppression doctrine so that we all have a common foundation to launch off from. And as part of that, I'd like to situate Michigan within sort of how I see the national landscape of oppression law and point out in a couple of places where I think Michigan is very different. So let's start a little bit.
Professor, you're on mute.
I was bragging about how I have taught from Zoom now for 2 semesters, and so I'm a complete Zoom master. And then, of course, this occurs. So please forgive the fact that I am not anywhere close to a Zoom master, and give me just one more moment to figure out very quickly, if I can, how to share my screen. So 1 second. Okay, I think I need to go to number 2. All right, is that better? Can you all see my slides? All right, well, God willing, you can see my slides. And if not, my guess is they're not that useful anyway. But at any rate, let's start with some background on what a closely held corporation is. As many of you are undoubtedly aware, a closely held corporation is a business organization. It is in fact a corporation. And it's typified by a small number of stockholders and the absence of a market for the company's stock and substantial shareholder participation in the management of the corporation. Now, if we were in a publicly held corporation, as most of us are aware, your typical shareholder is a passive investor. They don't contribute any labor to the corporation. They don't take part in any management responsibilities. Your basic shareholder in a public corporation invests money and hopes to receive a return on that money through dividends or sale of the company's stock at an appreciated value. But the closely held corporation is very different. In many, not all, but in many closely held corporations, the shareholders typically expect an active participatory role in the company, usually through employment as well as a meaningful role in management. And of course, like all shareholders, your closely held corporation shareholder also invests money in at least many instances and hopes to receive a return on that money. But by definition, there's no market. There's no active market for the stock of a closely held corporation. And so any investment return is normally going to be provided by employment compensation and dividends rather than by sales of stock at an appreciated value. All right, so what's the problem? By the way, I put in all these PowerPoint transitions to delight you. I hope they are delighting you. They're probably just annoying you. So what's the problem? So the problem is we've got these conventional corporate law norms of majority rule and centralized control, and they can lead to some serious difficulties for minority investors in closely held corporations. Now, why is that? Well, traditionally, most corporate power is centralized in the hands of the board of directors, right? And so the directors will set policy and elect officers and supervise the operation of the corporation. And because directors are elected by shareholder vote, the board of a closely held corporation is typically controlled by the shareholder or shareholders who hold a majority of the voting power. And through this control of the board, a majority shareholder or a majority group can dictate basically directly or indirectly every aspect of the corporation's business. Now, of course, exercising control in a genuine effort to benefit the enterprise and its owners is perfectly legitimate, even if that effort necessarily prejudices minority owners to some extent. But as we all know, the power to control also encompasses the power to abuse. And whether that abuse springs from greed or spite or intergenerational conflicts or some other reason, the minority shareholder in a closely held corporation has no viable escape route. And when the majority decides to act in an abusive manner, those actions are usually designed to restrict or deny altogether the minority's financial and participatory rights. And we usually refer to those as freeze out or squeeze out actions that have the effect of oppressing a minority shareholder. And if God willing, you're seeing my slide, you can see on the slide some common oppressive tactics: terminating employment of minority owners, removing the minority from positions of management, denying dividends, denying information, siphoning off earnings. And I should mention, these are just examples. Many cases will say that a single oppressive action can be enough to establish oppression. But I should point out that in most cases, you tend to see more than one of these. I'm gesturing over here to where I see the slide. You tend to see more than one of these oppressive examples, and not just those, right? I mean, really anything that's unfair can constitute oppressive conduct. Now, in the public corporation, of course, if you're a minority shareholder, you can escape any abuse of power that you perceive by simply selling your shares on the market, right? But by definition, that market exit is not available in a closely held corporation. Now, we might care less about that, and we might care less about the need for an oppression doctrine, even though there's no market, if the minority shareholder could basically demand to be bought out, right? If there was a default buyout right in corporate law, we might not care about the oppression doctrine because minority shareholders could get out. They would have an exit right. They could just demand, hey, buy me out now so I can recover my capital and move on down the road. But as most of us are probably aware, there is no state in this country that provides such a default buyout right. If you don't have a contracted for buyout provision in your shareholders agreement or in your organizational documents, your bylaws, your articles would be unusual, but I suppose you could have one there. If you don't have a contractual buyout right, you don't have a right as a shareholder to compel a redemption of your holdings. Now, we might not even care about that if it was easy for minority shareholders in a closely held corporation to dissolve the corporation, right? Because dissolution can also provide you with an exit. When we dissolve a company, we basically sell it and we get as much money as we can. We pay off the creditors, and then the shareholders get whatever's left over. They get their proportionate share of anything that's left over. So that would be a way out if a minority shareholder had the right to compel dissolution. But in every state in this country, that right does not exist. In every state in this country, at a minimum, in order to compel dissolution, you have to own a majority of the company's stock, which by definition, the minority shareholder doesn't. And in most states, you also have to have a board of directors resolution. So the bottom line here is, if you're an oppressed minority shareholder, what I'm trying to convey is there really are no effective exit rights. And that's probably the biggest driver of how the oppression doctrine came to be, to remedy this problem of shareholders getting frozen out with no exit in a closely held corporation. All right, so let me say a quick word about how has sort of nationally, how has the law responded to what we might call this oppression problem? Well, I would tell you there's two significant avenues of relief for an oppressed shareholder in a closely held corporation. In some jurisdictions, that relief is legislative. And in other jurisdictions, the relief is purely court-made. And in some jurisdictions, the two avenues coexist. But let's start by talking about the legislative relief. On this slide here, it says the statutory action for oppression. So let's talk about this for a moment, because over the years, many state legislatures have amended their corporate judicial dissolution statute to include oppressive conduct by directors or those in control as a ground for involuntary dissolution of the corporation. And again, hopefully you can see the slide, but I would tell you that's about 40 states. About 40 states in this country have what I would call a dissolution for oppression statute. Now, most of those statutes leave it to the courts to define what the heck do we mean by oppressive conduct. Michigan does not, which we'll talk about in just a moment. But so the courts, generally speaking, nationally have had to come up with a common law definition. What's meant by oppressive conduct in these dissolution for oppression statutes? Now, this will be important to our discussion of Michigan in a moment. Most courts define oppression as conduct that frustrates a minority shareholder's reasonable expectations. And if you look at that first sort of darker bullet point there, this is a pretty conventional definition. It came from a well-known New York case called Kemp and Beatley. Oppression should be deemed to arise only when the majority's conduct substantially defeats the expectations that, objectively viewed, were both reasonable under the circumstances and central to the minority shareholder's decision to join the venture. Now, other states, or courts, I should say, delineate oppression almost like just an unfairness standard. And so look at this second definition here. Burdensome, harsh, and wrongful conduct, a lack of probity and fair dealing in the affairs of a company to the prejudice of some of its members, or a visible departure from the standards of fair dealing and a violation of fair play, on which every shareholder who entrusts his money to a company is entitled to rely. Now, of those approaches, again, I would tell you that reasonable expectations is the most widely used. It's been adopted by the highest court of several states, and it's generally favored by commentators. Now, as I mentioned, there's also jurisdictions that have judge-made relief, and it won't surprise you that that tends to arise in states which lack a dissolution for oppression statute. And so in some states, the courts have stepped in, and they have imposed a fiduciary duty running from shareholder to shareholder, a direct action that a shareholder can bring against another shareholder for breach of fiduciary duty. And the best known example of this approach is out of Massachusetts, a case called Donahue versus Rod Electrotype. And this sort of goes back to where Mark started us, back to Meinhard versus Salmon. Let me just read you a quick passage from that opinion. We hold, this is from the Donahue opinion, we hold that stockholders in the close corporation owe one another substantially the same fiduciary duty in the operation of the enterprise that partners owe to one another. Again, hearkening back to Meinhard. In our previous decisions, we have defined the standard of duty owed by partners to one another as the utmost good faith and loyalty. And I should point out that a number of states have followed Massachusetts' lead, and they've imposed this fiduciary duty running from shareholder to shareholder in a closely held corporation. Now, although this legislative remedy, this dissolution for oppression statute, and this judge-made remedy, this common law action for breach of fiduciary duty, technically they're two separate doctrinal approaches, but from the 20,000-foot view, they really each reflect the same underlying concern for the position of minority shareholders in closely held corporations. They're each ways of saying we think special rules are needed to protect minority owners of closely held corporations. And so, yes, we should think of them as doctrinally separate, but again, from a general standpoint, they're basically jurisdictions saying we need to come up with some special rules because we think this freeze out problem is a problem. All right, quick word about remedies. Let me just mention, in most jurisdictions, the courts have the authority to offer a wide range of relief. And I mean relief short of dissolution. Dissolution is generally recognized as a drastic remedy. In jurisdictions that have a dissolution for oppression statute, the statute itself often provides the alternative remedies to dissolution, like Michigan, which we'll look at in a second. Even if the dissolution statute is silent on alternative remedies, most courts have found it to be part of their inherent equitable authority to grant remedies short of dissolution. In fact, most courts have rationale that goes something like this. The legislature gave us the power to kill the corporation, in other words, dissolve it. So surely we have the lesser included power to do something less drastic if we feel like that will solve the problem. Not surprisingly, in breach of fiduciary duty jurisdictions, since breach of fiduciary duty is generally seen as an equitable action, courts describe their authority in very, very broad terms. And my last point to you here is simply, these days, dissolution is an extremely rare remedy. What you typically see are these alternative remedies to dissolution. And I would tell you the most common alternative remedy today to dissolution is a buyout of the oppressed investors' holdings. And we'll talk more about that in a moment. All right, let me get over to Michigan. And by the way, I see you all chatting, and I know we have time for, oh, look at that one. That's my favorite, when the bird flies away. I know we have time after Professor Zaks for questions, so if you'll bear with me, I'll take a look at them as soon as I can. So let's talk about Michigan for a moment. So the Michigan has a dissolution for oppression statute. And the one we're looking at here on the screen is section 1489. And Michigan has an analogous LLC statute that's very similar. But let me just run through this very quickly. If you look there in paragraph 1, and I'm just going to paraphrase with the blue words here, a shareholder may bring an action, ... to establish that the acts of the directors or those in control of the corporation are illegal, that's one ground, fraudulent, that's a second ground, or willfully unfair and oppressive. So that is the third ground that we're obviously focusing on this evening. And notice that it says to the corporation or to the shareholder, which I want to spend some time chatting about. If you'll notice there, A, B, C, D, E, F, Michigan is one of those statutes that actually lists alternative remedies in the statute. So the court doesn't have to grant dissolution. The court can grant any relief, quote, as it considers appropriate. And this is just some examples. It's not an exclusive list. If you'll notice, E on there is a buyout remedy. It's explicitly a part of the Michigan statute. Subsection 2 basically says if you own stock in a publicly traded company, you can't use this statute. You already have a market exit. You don't need an oppression remedy. This is for closely held corporations, which by definition don't have a market. And subsection 3, which we'll talk about in a few moments, actually defines what's meant by willfully unfair and oppressive. Okay. Let me talk about a couple of things that jump out at me when I look at the Michigan statute and some Michigan case law and I compare it to national trends. Okay, this is sort of a list of, in the next 12 minutes or so, what I hope to get through. And so the first thing I want to talk about is that language we just saw about oppression to the corporation. And I think I blew that up again. So here, this first paragraph is that same subsection 1, a portion of it that we looked at a moment ago. And remember what it says, you can prove that there's the directors or those in control have acted willfully unfair and oppressive to the corporation or to the shareholder. Now, I will tell you that oppression to the corporation is an unusual concept because the oppression doctrine was not developed to address corporate harm. We already have derivative lawsuits for that. The oppression action developed to address harm to the individual shareholder. And just to try to bang this point home a little bit more, that language to the corporation that you see in Michigan is not present in most state statutes. I'll just give you an example. The New York dissolution for oppression statute says the directors or those in control of the corporation have been guilty of illegal, fraudulent, or oppressive actions toward the complaining shareholders. That's what you typically see. Now, when I was here last year, I learned that the Michigan oppression statute, the one we're looking at, actually derived from the South Carolina statute at the time. And I mean going back to, I believe it was 1970 approximately. And that South Carolina statute that Michigan borrowed their statute or derived their statute from did actually have that language, oppression to the corporation. And more interestingly, even the current South Carolina statute still has that language. And let's just take a look at that. It's on the slide and it's this bottom half. This is the current South Carolina statute. The directors or those in control of the corporation have acted, are acting, or will act in a manner that is illegal, fraudulent, oppressive, or unfairly prejudicial. So notice that it breaks up that ground, drops the willfully, which we'll talk about in a second, either to the corporation or to any shareholder. So you see that language again. And then it says, this is very important, whether in his capacity as a shareholder, director, or officer of the corporation. That's going to be very significant to us. Okay, now I have a theory about this language to the corporation, which you may feel totally free to reject. But if you recall, the oppression, this statute also covers illegal conduct and fraudulent conduct. That is often conduct that harms the corporation. And my suspicion is that perhaps this language of to the corporation was meant to apply to those grounds and not necessarily to oppression. But regardless, whether you agree with my argument or not, it's definitely been the case that this language has been significant in Michigan judicial decisions. And let me just tee this up for a moment. Many jurisdictions confront the following problem. What happens if the directors or those in control do bad things that harm the corporation, and they only indirectly harm the minority shareholder because the shareholder is an owner of the corporation? In other words, assume with me that those in control do things that you would normally bring a derivative lawsuit to remedy. So for example, a conflict of interest transaction that's unfair to the corporation, or maybe the majority is using corporate assets for personal purposes. Can you bring a direct action as an individual shareholder? Can you bring a direct action for oppression based on harm to the corporation that is only indirectly to you? This is a hard question in a number of jurisdictions, but it's not hard in Michigan. There are Michigan cases that point to this language, oppression to the corporation, and say, yes, you can. The statute says that oppression to the corporation counts as oppression. So let me just say that in Michigan, this language makes the oppression cause of action much broader than you see in other jurisdictions, because it's not limited to a special injury to the minority shareholder itself. Okay, but in another sense, the oppression cause of action in Michigan is much narrower than you see in other jurisdictions. And let's chat about that for a moment. So let's look at, this is subsection 3 of the statute that we didn't really focus on a moment ago, but let's focus on it now. This first paragraph, the Michigan statute defines oppression. And look what it says: willfully unfair and oppressive conduct means a continuing course of conduct, or a significant action, or series of actions that substantially interferes with the interests of the shareholder as a shareholder. Now that language, as a shareholder, I would again tell you is unusual. In fact, I would say that language is diametrically opposed to most other jurisdictions that via statutes or case law explicitly indicate that oppression can be to a shareholder in his or her capacity as a shareholder, as an employee, or as a director. Again, just taking a look at the current South Carolina statute again here at the bottom, right? Look at that bolded language. South Carolina still has that to the corporation language, but it's added this parenthetical about your capacity as a shareholder, director, or officer of the corporation. Okay, now this language matters because, as many of you are aware, you've got case law in Michigan. Like the case that comes to my mind is that Franchino case, where the court said, look, we only protect you as a shareholder. And what the heck does that mean? Well, it means we're going to protect your traditional shareholder rights, things like dividends and voting rights and inspection rights. But employment's not a traditional shareholder right. And being a director is not a traditional shareholder right. In fact, in Franchino, the minority sued and alleged oppressive conduct based on his removal from the board and his termination from employment. And the Michigan Court of Appeals said, sorry, that doesn't affect your interest as a shareholder. And once again, I just want to emphasize this is very, very different from other states that have case law indicating that terminations of employment and removals from management, denials of participatory rights, in other words, are very common grounds for oppression-based relief. Now, Michigan amended their oppression statute after Franchino. And if you look on the screen here, that second paragraph, notice what it says: willfully unfair and oppressive conduct may include the termination of employment or limitations on employment benefits to the extent that the actions interfere with distributions or other shareholder interests disproportionately as to the affected shareholder. Now let's talk about that for a moment. I don't think that provision builds back in protection for employment as a participatory right. But let me just explain this for a moment. It is true that there are a number of closely held corporations where employment is the vehicle for distributing profits of the firm. Now, why is that? Because the corporation can take a tax deduction if it characterizes a distribution of cash to shareholders as employment compensation, but it cannot take a deduction if it characterizes that distribution as a dividend. And of course, this is assuming we're not talking about S corporations. So in many corporations, this is really my point, the company has a tax incentive to pay out what really are dividends, but to disguise them as employment compensation so that the company can take a deduction. So if you're in a corporation like that, where all the profits get distributed as employment, if you get fired, that effectively results in an elimination of your ability to receive a financial return on investment. And so in that kind of situation, the Michigan statute does protect you, because employment there, when you get fired, that is interfering with distributions. But I'm not sure the language does anything if employment is merely a participatory interest and doesn't have this financial return on investment component. And let me just point out that there's nothing in there about protecting a position on the board of directors. A board seat is not an employment position. So in this sense, Michigan's oppression action and what it will protect is actually narrower than what you see in other jurisdictions, as it doesn't appear that participatory interests are protected for their own sake. And I happened to run across this case, MJC Ventures, Eastern District of Michigan, from this summer, June 30th of 2020. Let me just quote a little bit from the case. The court says, exclusion from corporate governance is not recognized as minority oppression under this statute. Corporate governance is not a shareholder right and therefore not actionable under Section 1489 by plaintiffs as a shareholder interest. Nor does Section 1489 permit shareholders to recover for harm suffered in their capacity as employees or board members. So there you go, right? That's sort of the court making the narrower point that I was trying to make. Okay, very quickly, let me just wrap up these two other points. Oh, I'm already getting played out. Oh boy, okay. So Michigan's got this definition of oppression in the statute. And let me just point out that that definition of oppression is its own. It's not reasonable expectations. It's not burdensome, harsh, and wrongful conduct. And so I sort of wonder in Michigan, is it difficult to look to precedents from other jurisdictions? Because it's always the case that someone can argue that Michigan has a different definition of oppression. Very last point. You all have this case, Franks versus Franks. And to establish oppression, you have to prove that the majority did the oppressive actions with the intent to substantially interfere with the shareholders' interests. And the court makes the point that if you can show you intended to act for a legitimate business purpose, then that's a defense to oppression. And I just want to raise the question of what happens with a mixed motive in Michigan, right? It's not always the case that people act with a solitary motive. if you act both to benefit the company, but also because you want to stick it to the minority shareholder, how does that work itself out given this Frank's requirement? Okay, well, I only have 29 minutes according to my stopwatch, but because I'm getting played out and I don't want to walk all over my colleague here, let me stop there. I'll take a look at the chat and we can hopefully discuss some more during questions and answers.
When I think back on all the crap I learned in high school, it's a wonder I can think at all. And my lack of education.
For the second half of this academic segment, please welcome Professor Eric Zaks from the Wayne State University Law School. Professor Zaks is going to present on the business judgment rule, its application, and how it should be considered at the pleading stage. Once Professor Zaks concludes his presentation, we will have a 25-minute period of dialogue between the professors, and you are very welcome to submit your comments and questions in the chat box. Professor Zaks, take it away.
Well, thank you, and good evening, everyone. Thank you to Mark and the Rossman firm and the co-sponsors. Obviously, I'm happy that Wayne State's involved with this, the Journal of Business Law, which I was involved with as they got started. Really excited. And at this point, I've been out long enough, or I've been in the academy long enough where among the participants, I see more of my current students or former students than I see former partners or colleagues. So I guess that's just a sign, but it's nice to see you all here tonight. So I'm going to try to quickly get to the topic that we're all here for, but I do need to situate what I'm doing because it's part of a larger project. Really, the larger project was just the business judgment rules applications to pleadings generally in the fiduciary duty context, because and again, this project is in its infancy. I became aware a few years ago on two different but related issues concerning the business judgment rule. Because of Iqbal Twombly, does it require substantively different pleadings with respect to the business judgment rule? How does it apply at the federal level? And does the business judgment rule in the first place even apply at the pleading stage? Now, as I was beginning my research, I started talking with Mark, and he asked me to speak. So I sort of, this is sort of a diversion, maybe a little bit of a tangent, and took a pause with that and sort of really considered the business judgment rule with respect to oppression. But to get to the oppression parts, I want to talk about sort of how we get there. Starting with some of the basics, talking about some of the pleading issues, the splits that have come up, and then particularly in the oppression cases in Michigan. So again, the basics, when we're talking about breach of fiduciary duty, the business judgment rule, which everyone hopefully remembers from corporations. I'm looking among the participants to see which of my current students I can test this week, because we're actually covering the business judgment rule this week. But the presumption basically that the directors did their job, right? So they acted in good faith with requisite care, loyally, and all that. And the consequence is that if the plaintiffs cannot rebut it, then the case can get kicked, right? So, and one of the issues that comes up is, well, when do we evaluate that, right? So how do we, when we say the directors are entitled to that, when do they get the protection of that? And what I was interested in was looking at, well, do you get the protection of that at the pleadings level, right? So can you, if someone, or again, motion to dismiss for failure to state a claim, can you get it kicked at that point? And there's, again, two general approaches, and one says yes and one says no, but they can get tested. Again, the business judgment, I sort of put it up here, that you obviously can get tested later, right? So on a summary judgment motion, but I was really focused on more of the earlier stage. And again, this can raise some, on the pleadings themselves, it can raise some interesting questions when the case is brought in federal court. Under the older notice pleading standards, some cases held that the business judgment rule did not apply at the federal level. You had to allow for factual discovery, and you didn't want to preempt claims by imposing some sort of pleading with particularity requirements, including the application of the business judgment rule. So business judgment rule is providing you with this protection, this presumption. It might have been more difficult to overcome it if you were going to apply that standard, and maybe it wasn't appropriate if you're applying the federal notice pleading standards. Now, again, some of those decisions, that the most, I think, famous of which is Tower Air, came out before Iqbal and Twombly, which imposed the plausibility requirements, the heightened standards for federal court pleading. And it's really unclear of those impacts on the more broad Tower Air holding that the business judgment rule isn't really, it doesn't need to be, doesn't apply at the federal level. Now, there's cases out there since Tower Air among the different circuits that say the federal pleading standards do require a plaintiff to overcome the state's statutory business judgment rule. And still other courts, though, whether or not they discuss Tower Air, and sometimes without discussing the impact of the federal pleading standards, they just decide the business judgment rule is not appropriate at the pleading stage, regardless of the pleading standards used. So that takes us to really to Michigan. And without addressing sort of, again, the split of authority that exists elsewhere, which is, again, sort of my larger project, Michigan courts have typically held that a party must plead sufficient facts to overcome the business judgment rule and survive a summary disposition for failure to state a claim. So if you look back at, again, I guess 18 years ago, the Trella case, and this is a common fact pattern, by the way, in a lot of these breach of fiduciary duty as well as oppression claims, but these failure to pay dividends. The policyholders of an insurance company brought suit against the company and the directors, seeking to compel them to pay, to distribute out of the excess surplus. And on appeal, the Michigan Court of Appeals upheld the trials court decision, holding that the policyholders did not have a right to compel distribution of a surplus where they did not sufficiently plead facts to overcome the business judgment rule. So in order to determine that a claim was legally sufficient, the court would have to decide that the policyholders were not precluded by the business judgment rule from bringing suit. But because they did not explain how the directors' failure to consider distribution constituted fraud or bad faith dealings, because they didn't cite any cases to that point, they found that they did not sufficiently plead facts that would overcome the business judgment rule. And that's been reiterated in a few holdings, a couple unpublished decisions since, and at least one federal court in Michigan has followed Michigan law in requiring a party to plead sufficient facts to overcome the business judgment rule. And that's the CMH liquidating trust case where a liquidating trust filed an adversary proceeding against a hospital's former officers and directors alleging breach of fiduciary duties, and they responded by filing a motion to dismiss because they didn't plead sufficient facts to overcome the business judgment rule. Now, the court ultimately found that they had pleaded sufficient facts, but they did say that the business judgment rule does apply here. The plaintiff must plead sufficient facts to overcome the business judgment rule. And the court took notice in a footnote that there is a split, right? That there's a split in other jurisdictions where you shouldn't have to plead, you shouldn't have to plead sufficient facts, or it's a question of facts where the business judgment rule is not applicable at the pleading stage. So in summary, and again, I went through that I hopefully relatively quickly, just to say that you should be aware, obviously, of the business judgment rule pleading issue, depending on the court that you're in, again, and also whether or not you're at the state or federal level. And this has obvious ramifications for oppression cases if the business judgment rule applies there in the first place. All right, so let's go to relevance to oppression. So it could come up in just a summary judgment case, and I'll get to the Franks case in a minute. But just to say that some states do not use the business judgment rule in oppression cases. They just say it's not applicable, it's not relevant. There's a number of theorists out there. I think Professor Moll has written on this, that it may not be appropriate to consider whether or not a business judgment or decision, that the process by which it was made maybe that's not really relevant when we're trying to test the minority's expectations of whether or not they were frustrated. So another number of states have rejected. I think New York and New Jersey, Massachusetts, there's some others have said business judgment rule oppression cases, not relevant. So that obviously has implications for pleadings and for summary judgments as well. Now in Franks, the business judgment rule was held to apply, and I'll explain how I get there in a second, but it should be remembered it was a C8 and C10 in motion, and the decision largely dealt with the summary judgment, what I'm going to call the summary judgment aspects of it. And it said that, look, they provided evidence demonstrating, and if you demonstrate acts that are inherently wrongful, that necessarily means you overcame the business judgment rule. So if you present evidence that decisions were not taken for legitimate business reasons, but instead to oppress the shareholders, then you can overcome the business judgment rule and survive motion for summary disposition. Now, and again, in some cases, there's some other cases out there, this proposition hasn't really been tested. It's not, the business judgment rule hasn't been raised every time. So now, Franks was interesting for a couple of different points. One, it wasn't clear to some upfront whether or not the business judgment rule was actually doing any work here, whether or not it was actually applied. And some have argued that the court, that it actually does not apply. They were just saying, look, all you have to do is plead sufficient to get to oppression. And if you do that, which you have to do anyway, you've overcome the business judgment rule. But there have been decisions that have suggested that, and again, this is a 2020 case, that the business judgment rule does apply, right? So it is relevant in some way. The court was just saying in Franks, at least according, on this decision, was saying that, well, we have to look at it, right? So we have to see whether or not you overcome the business judgment rule. And hey, if you do plead facts, it's going to overcome the business judgment rule. You may still counter that. That's not doing much work. But I think, and again, we'll return to this at the end, but I think if you couple with the limitations in the oppression statute that Professor Moll was talking about, and some of the other things here, I think there is some work that the business judgment rule can do from a defensive posture. So again, at least in this instance, you had it is relevant. Now in other states, just to give you a flavor, again, these and all these that I'm showing you, I'm gonna get to a pleadings case in just a minute, but just to show you how these end up playing out. If you plead sufficient facts to put it in question whether or not the business judgment rule applies, or whether or not you rebutted the business judgment rule, you're going to survive, right? So that's the idea. You at least on summary. So this was a Missouri case that both parties agreed on the facts. They just couldn't agree on the characterization of the facts. Okay, fine. Well, that case is not going to be dismissed. Now, if you don't, though, there's a couple other cases on point. So another Missouri case said, look, you just said that the valuation method that the board used to value shares was not good. That's not enough. And again, these are on summary judgment. These weren't on failure to state a claim, which I will get to that in a minute. But again, you can see where if you don't plead sufficient fact, if you don't show enough evidence, you might lose on summary judgment because of the business judgment rule. So business judgment rule might have teeth at summary judgment, might have teeth at the pleading stage. And then in Texas, went so far as to say, look, you can't have oppression unless it's inconsistent with the business judgment rule. So it actually uses that as a reference point for determining whether or not conduct is oppressive. Okay, so did Franks did it speak to the pleadings alone? Okay, so again, the Franks case appeared to only be looking at the C10 motion and didn't extensively address the C8 motion, the pleadings requirements. It did suggest, it said they allege, so maybe we're talking about the pleadings requirements, in addition to providing evidence, the facts that the business decisions were improperly taken, and so on. And after making this statement, the court only wanted to discuss the facts and the evidence presented, which really went to the C10 motion, not the sufficiency of the pleadings. So arguably, the business judgment rule would still apply to a C8 motion, at least based on the Franks case. And again, the MJC case that Professor Mole just referenced, the more recent case suggested that a plaintiff's allegation that the defendants also engaged in shareholder oppression by refusing to declare dividends, despite their ability to do so, is further foreclosed by the business judgment rule. So and again, this was a failure to state a claim motion, and it was kicked. And again, the other claims that were involved here, being excluded from governance, claims in other capacities other than shareholders. So the business judgment rule did have teeth to the extent not only does the oppression statute provide for more limited avenues of, or in terms of the claims that can justify relief, as Professor Mole outlined in his lecture, to the extent that it narrows those grounds, the business judgment rule may have some teeth and provide some protection as well. That look, you're not even getting to the point where you're going to survive a C8 motion. I do want to point out there is some, again, there's not a ton of cases out there on this, right? So this stuff is developing. I did want to point out also, this is a pre-Franks case, but it's an LLC context. But in this, I believe Circuit Court, Oakland County Circuit Court opinion says that, look, a C8 motion involves factual determinations. It's not appropriate here. So we're not gonna deal with it. So again, this is pre-Franks. It doesn't, again, and pre sort of the elucidation in MJC as well. But I do want to point out there, I don't know that it's firmly settled what you have to do, at least with respect to oppression in the business judgment rule. But if MJC is right, if the reading of Franks is right, that it is relevant at the pleading stage, if you don't please allege sufficient facts that would overcome the business judgment rule, so alleging the facts that those in control that are illegal, fraudulent, and the standards, again, that my colleague outlined, then the pleadings wouldn't survive. And again, maybe that doesn't mean much, right? We academics, we get to worry about things that maybe they don't matter much because on the pleadings you're going to amend and you're going to refile. And maybe a good litigator is always able to satisfactorily plead oppression, right? I mean, if you've got, again, you got to have some facts, but if you only have some facts, maybe you can spin it, right? And you would necessarily overcome the business judgment rule, and the business judgment rule doesn't do much work. And that may be true on the plaintiff side. I don't know. I'd love to hear from those of you, in the field doing this, talking about how you feel about that. I think where it may have more relevance is on the defense side, where the closer that a decision looks to an ordinary management decision, the business judgment rule in Michigan looks like another lever to pull or another reference point you should be hammering when making a C8 motion or the federal, the federal equivalent of the summary judgment. So it's not just that the facts pleaded aren't enough to show oppression, so you argue, but bear in mind that these facts must be sufficient to overcome the business judgment rule. Nothing pleaded shows that this was anything but an ordinary management decision. It was valuation. It was whatever the decision was. The business judgment rule, this is well within the director's ambit, and it serves as an anchor or a frame of reference, and start there. And maybe again, that's possibly a way of framing it. Again, so when we're talking about dividends or at-will employment, again, these are possible strategies that can be used on the defense side. I'm very interested though on the claims pleading side, how all of you are framing in terms of how you are pleading, what you're thinking about. Are you thinking about having to address the business judgment rule up front, or are you just trying to make sure you're meeting statutory requirements for oppression? I'd love to hear what everybody is thinking about. Again, this is very much in its infancy, but I very much look forward to your questions. And this is a discussion. Again, this is an early stage project. Thanks very much. And I'm going to play my own music to get out of here. So I'm going to play some Beastie Boys and get out of here.
Thank you very much, Professor Zaks. We would like to open it up between Professor Mull and Professor Zaks to have a dialogue and speak back and forth if you would. We have 20 minutes for you to engage in conversation. Thank you.
Okay, well, can I react, Eric, to some of the stuff you said?
Sure. Don't ask any tough questions though. I'm used to be on the other side of that. So but go ahead.
Well, I'm trying to see, we also have some questions in the chat, but let me just say, first, my view is your project is very interesting because I will say personally, and I don't want to take up too much time because I would like to hear from some of the practitioners. I think pleading the business judgment rule and where is it pled and when does the court make the decision that that's going to apply or fairness is going to apply is a total mess. It's a mess to teach. I mean, I don't fully understand when you have to allege sufficient facts to get past the business judgment rule, and when does the court decide whether there has been a lousy decision-making process such that we're now going to get the entire fairness standard. I'm talking Delaware language here, but anyway, so I think that's great. And I will just say for my own personal purposes, the relationship between oppression and the business judgment rule is also a complete mess. And I just want to say 30 seconds on this and I'll stop talking. I have always assumed that if you are a plaintiff's attorney bringing an oppression claim and you're worried about, I agree with you, the defense should always raise employment at will, even though I don't think it technically applies, but I would raise it, and I would raise the business judgment rule. And I think the plaintiff has got to first address it just traditionally and say, I'm alleging bad faith. These guys are acting in bad faith towards my client, which is normally something that will rebut the business judgment rule. Or most oppression cases are just a conflict of interest. Normally the majority is freezing out the minority to sort of capture some of the income stream that would otherwise be going to the minority. When you have that, you can argue traditional conflicts of interest to get you past the business judgment rule. But I cannot emphasize this enough, and I will admit that this is just Doug Maul's personal opinion. The oppression doctrine is clearly displacing the business judgment rule because the things the oppression doctrine is asking are not what the business judgment rule asks. And so maybe the easiest way to say it is, Massachusetts, they say, what's the legitimate business purpose? And then the minority gets a chance to say that legitimate business purpose could have been accomplished through a less harmful alternative. That kind of balancing, that's not the business judgment rule. The business judgment rule doesn't balance anything. The business judgment rule is if you can articulate a legitimate, a rational business purpose for what you did, game over. We don't ask any questions like, was there a less harmful way to do it? And I think Michigan is similar. I think the Franks court actually got it right when they've got some sentence that says, look, if you can prove that you met that willfully unfair and oppressive definition, you have by definition overcome the business judgment rule. That is way more scrutiny than the business judgment rule would normally give. Anyway, let me stop talking there.
Just a quick reaction, then let's, I'm happy to open it up for, for others. I think that's probably right. I mean, I think if you plead it sufficiently, as you said, under the Franks, then you probably get there, right? But that, I guess maybe again, I'm interested to hear what the practitioners actually do, right? Is that what you're aiming to do? Like you bypass anything dealing with the business judgment rule in your pleadings because you're just going to allege enough stuff that'll get you to oppression. But if you're if you're defending the claim, that's when you may try to invoke business judgment rule. Like you said, that's what you would always do, because even if you, like you said, if it's irrelevant, it's irrelevant. It doesn't mean it's not a good point to raise as, and say it's a management decision.
Totally agree. And one more just 10-second point here. The fact that in Franks, they say that if you're on the defense side, you can raise a legitimate business purpose to rebut the element of you acted with the intent to, harm me as a shareholder. If you have to prove a legitimate business purpose, that is not the business judgment rule. Right. The business judgment rule, and again, I don't think this is a professorial argument, but maybe it is. But the business judgment rule is you don't have to prove anything. If the court can even come up with a rational business reason for you doing what you did, game over. In Michigan and in most oppression jurisdictions, you got to prove a legitimate business purpose. It can't be a pretext. You actually got to come forward with evidence and establish it. And in some jurisdictions, even if you establish it, the minority gets to say, yeah, but you could have accomplished that purpose in this much less harmful way. That is way beyond we are way past the business judgment rule when you're having to establish a legitimate business purpose and balance the minority's interests. So let me just say, I'll just throw out some questions that I see here in the chat. One of the questions was, does Frank's make it easier to get summary judgment, I think? Yeah, does it increase the likelihood of summary disposition or decrease it? I've got my 2 cents worth, but Eric, why don't you, do you want to?
Yeah, I mean, I think we sort of talked about it, right? I mean, if you're already, to the extent you think it's important because it does raise the specter of the business judgment rule, maybe it's useful because it just was used in MJC, right? It was invoked in MJC successfully, but maybe it would have come out that way anyway if you couldn't demonstrate what the statute already provides, right? So if the oppression statute stands on its own, and the quote that you talked about, it, by proving oppression, you've already overcome the business judgment rule, and the business judgment rule is never relevant. You haven't changed much. But again, I'm speaking just to the business judgment rule, but I'm a more general question. I'll let you sort of jump in on.
Well, I guess I would just say, you know, if Frank's does require a motive inquiry, at least that's what I'm going to call it. I think it's really a motive inquiry. We're going to say, why did you do what you did? Was it to harm the interests of the shareholder or not? I think that's going to make it harder to get summary judgment because, at least generally, you know, motive is fact intensive. And so it seems like that's good for, well, I don't know. It's annoying for plaintiffs in that they're going to have to establish apparently this intent to harm the shareholder, but it would suggest to me that it's probably harder to get summary judgment.
Just a quick follow-up on that. Also, most of the cases that resist using the business judgment rule resist it for just that reason, right? You're talking about intent and motive and things like that, and things they don't want to kick it early, right? When there's facts to be developed on it. So that part of the resistance there is not, they just don't want to business judgment rule. And again, maybe that's what that other LLC case is sort of referring to. Is like there's a lot of stuff going on here that we have to determine why the board was doing what they did. It's not really appropriate to kick it on a C8 or C10.
Yeah, I think that's a great point. And let me just say, somewhere also going on in here, and I'm not sure I can just sort of set up the problem, but I'm not sure I know how to solve the problem. The business judgment rule was largely designed for when you make a decision to benefit or not benefit the corporation. The business judgment rule was not really designed to deal with issues when you owe a duty to an individual shareholder, which is what oppression, particularly in Michigan, you owe duties to the shareholder, not just to the company, but to the shareholder. The business judgment rule fits pretty well when someone's making a decision of, look, I'm the majority and I get to steer this company where I want to. That's what it means to be the majority. And when the minority says, yeah, I wish you wouldn't steer the company that way, that should be a loser. That should not be an oppression claim. That should be a classic business judgment rule decision. But when the majority makes a decision that impacts the minority in a unique way, you fire me, you threw me off the board, you cut off my dividends, that's not the typical business judgment rule scenario. The business judgment rule analysis is designed for decisions that affect the company, not for decisions that are affecting individual shareholders. And so I've never fully understood how the business, like to me, as Professor Zach said, I just wish courts would just acknowledge, almost like Frank's did, look, the business judgment rule doesn't apply to these oppression disputes. If you can meet the oppression standard, we have required you to satisfy a much higher hurdle than the business judgment rule ever would have required you to satisfy. So if you meet oppression, there is no business judgment rule. That to me is just a much quicker way of getting through all this.
Yeah, I think that's probably efficient. I guess, you know, one point just to push back on, maybe it's not really a pushback, just in the cases sort of that I've come across with the business judgment, you know, with the business judgment rule, the dividends is always hammered home as a principal board decision, well with, you know, sort of a quintessential board decision. Now, I know it's ripe for abuse, but in terms of the cases, you know, particularly Michigan that are out there, a lot of them deal with failures to pay a dividend, and you can't just say you should have paid a dividend, right? You have to go further than that. And why? Partly because it's a business judgment of the board, and that's who's supposed to be making distribution decisions. So
I agree. I agree. I think those dividend cases, when you're saying they are paying dividends and I'm not getting my share, they've disguised the dividends as employment compensation and I'm not getting my share, those cases are easy. Those should be winners. You can call those oppression, you can call them illegal dividend, you can call them conversion, you can call them a million things. But I agree with you, Eric, when the claim is, oh, we're not paying dividends, I just think as the minority shareholder that it's about time. That
Right.
can be very difficult to win. And I agree with you that there is a specter of the business judgment rule in those kinds of cases. And let me ask you a different question, Eric, that's in the chat. Somebody mentioned, similar to the points we just made, the business judgment rule was developed in conjunction with derivative actions, doesn't seem to apply to direct actions for oppression. I think I kind of agree with that point. But maybe the question for you, Eric, that I think relates to pleadings, given that the assumption underlying the business judgment rule is that the court should defer, how is it even possible to resolve this issue before trial? So I guess the question is, if the business judgment rule is all based on the courts deferring, how is it possible to resolve this issue before trial? I'm not sure what this issue, maybe John can elaborate.
I think I probably just presumably the general claim. Well, if you haven't pleaded, for example, overcoming the business judgment rule, if you think about it just in a normal breach of fiduciary duty case, and maybe in this case, maybe he's going to your point, Doug, to say that in an oppression case, you've got to prove a certain state of mind or motive and things like that. And if you have to do that, how are you supposed to resolve that on the pleadings or beforehand? Maybe it's to that point, because obviously you could have business judgment rule does apply and does kick cases, even though there might be facts to be developed. But if you can't develop them before a certain amount of time, it's going to get kicked.
Yeah, and I should mention, and I think everybody gets this drift, right? Every state sort of articulates the business judgment rule in different ways. But if I was to try to boil it down, I think a fairly general encapsulation is there is a presumption. If you're challenging a board of director decision, presumptively you lose. That's sort of the effect of the business judgment rule. Presumptively you're going to lose unless you as the plaintiff can displace the business judgment rule. And you can displace it if you allege in most jurisdictions bad faith, and that's a whole mess about what constitutes bad faith, a crummy decision-making process, or a conflict of interest. If you can allege one of those three, then you tend to either get a different standard of review, like entire fairness, which is a lot more scrutiny on the board's decision. But I guess, I guess the idea is I've always thought the way the business judgment rule can be used to resolve things on the pleadings is that if you don't come forward, if your only allegation in the petition is, I think the board made a stupid, dumb, unwise, whatever adjective you want to put in there, terrible, lousy decision. Like on the merits, that decision was bad. You don't allege a conflict. You don't allege bad faith. You don't allege a bad decision-making process. You just walk into court and say, I totally disagree with the decision the board made. To me, that should get thrown out on the pleadings. That business judgment rule should dispose of that, and there's no fact question to discuss. But anything beyond that, any allegations of bad faith or a conflict or a crummy process, or oppression, which I think kind of displaces all of that, gets you past the pleading stage.
Right. I agree. I just think there's some confusing overlap about when we talk about what constitutes oppression, right? There's similar things that would overcome the business judgment rule. And then are they mirror images of each other? And I think we're still trying to sort that out based on the language of Frank's and some of these other cases that are out there. I want to make sure we're getting other.
Yeah, I agree. I think it's a good point. Let's see. We talked about that. I'm just looking at the chat. Given the assumption, okay, we talked about that. Yeah. So somebody asked, the business. So somewhere going on here, and I feel pretty confident that Professor Zaks is having the same thought that I'm about to say here, which is a lot of what we call oppression tends to overlap with what we would normally call breach of fiduciary duty that has nothing to do with oppression. In other words, I like to say it like this: Delaware does not have an oppression doctrine. They've got a Supreme Court case that explicitly says we're not coming up with any special rules for closely held corporation shareholders. And so someone asked in the chat, what would happen if, for example, the majority shareholder engaged in an interested transaction? You know, they sold, you know, they bought stuff from the company at below fair market. Why? Because the buyer was, you know, a related company to the majority. You don't need oppression. You could bring that claim in Delaware and you would say that is a classic conflict of interest. The business judgment rule doesn't protect it. Entire fairness is the standard, and you'll fight about whether the price that was paid was fair. In Michigan, you could do the same thing, but you could also bring that as an oppression claim. I've always sort of wondered, what's the advantage to bringing it as an oppression claim? Well, number one is, particularly in Michigan, you get to avoid the derivative lawsuit. You need to meet any of the derivative lawsuit requirements because the statute appears to say you can bring in direct action, even if it's harm to the company. And the second thing that you all would know probably better than myself is a buyout. A buyout's not, if you're trying to get a buyout as a remedy for breach of fiduciary duty, there are some cases across the country that say that is an appropriate remedy, but not a lot. But in oppression, there's a billion. There's a billion cases that say a buyout is an appropriate remedy for oppression. So I've always thought that might be the second reason that it's advantageous to have an oppression action, even though it's the kind of thing you could bring derivatively, is because you don't have to fight the fight about getting a buyout.
Right, that's the hammer, right? Yeah.
I think in most cases. Someone points out that statute of limitations is different for oppression compared to derivative actions. So that's a good point, and I don't know the answer to this. In a lot of jurisdictions, it's very unclear what oppression is from a statute of limitations standpoint. So for example, I think that oppression is, quite frankly, just the flip side of breach of fiduciary duty to an individual shareholder. And so it should get the same statute of limitations as breach of fiduciary duty. There are jurisdictions that say, however, oppression doesn't have its own statute of limitations. It goes into the residual statute of limitations, which the jurisdiction will have some statute for, like everything else that we haven't specifically named gets this statute. I don't know. Do you all know here, is there case law that says what oppression statute of limitations is as if you bring the cause of action under the dissolution statute?
Sure.
The chat is suggesting that it is a different statute of limitations compared to fiduciary duty derivative actions. I don't know if that's true, but if it is, that's another good point. And attorney's fees, okay, you can get attorney. So that's interesting too. I mean, someone points out you can get attorney's fees in an oppression claim and not for breach of fiduciary duty. Now, that strikes me as odd. Is that a matter of case law in Michigan? Okay. For those of you, for whatever reason, don't care to look at the chat, the response is, per case law, the statute of limitations for oppression, okay, is the residual 6 years. Okay, so in Michigan, yeah, you get the residual statute. Okay, interesting. Well, any parting words, Professor Zaks?
No, I was hoping to actually hear from some of the practitioners in terms of how their pleading practices may have changed since since Frank's or some of the recent decisions. So maybe in some of the future chats or sessions, people might raise that. I'd be very interested to hear people's actual practices.
Well, I guess, thank you all very much. Thank you, Professor Zaks, for doing this with me. And maybe
Good to see you again.
Maybe we can do it again next year and we will all be physically in the same place.
A very special thank you to Professor Zaks and Professor Moll. Please welcome now Bill Winston. Mr. Winston has particular insight into one of the most fundamental precedents in corporate fiduciary context, production finishing versus Shields, because he litigated the case in both the trial court and appeals court. Thank you for coming here tonight, Mr. Winston, and sharing the backstory on this case and your insights on the corporate usurpation doctrine, which oftentimes factors prominently in corporate oppression cases. Mr. Winston, you have the floor.
Thank you, and that was a good choice of music. Start me up on a theft of corporate opportunity case. I also want to thank our two good professors for an excellent presentation, including my former partner, Eric Sachs. So I've been asked to present the backstory of production finishing versus Shields. I once told this story to Mark Rossman during a break in a case I was mediating for him. And as a result of that, he asked me to do the same thing here today. So production finishing versus Shields is a 1987 Court of Appeals, Michigan Court of Appeals decision found at 158 MISHAP 479. It is the leading case in Michigan on the theft of a corporate opportunity, and it had seemingly harsh results for Peter Shields, who was the defendant. As I will explain, the case did not end up that way. The Court of Appeals decision in 1987 held that an officer or director like Shields, who takes a corporate opportunity, must disgorge the benefit of the opportunity to the corporation. And the Court of Appeals held that Shields was barred from relying on his principal defense that the potential opportunity had refused to deal with the corporation because he did not disclose that purported refusal to deal to the corporation before he began to pursue the opportunity. The court reversed a jury decision for Shields, held Shields was liable as a matter of law, and remanded for a new trial to determine the amount that he must disgorge. I then tried the case on remand. Here is the very different backstory. Shields ended up, in effect, winning the case. Peter Shields was the president and a director of production finishing. He was not an owner. He was not a shareholder. Production finishing had a niche business as a supplier to the auto companies. Production finishing polished chrome bumpers. This was thought at the time to be a dying business, as the industry trend then was to move to plastic bumpers, and the surge in the sale of trucks with steel bumpers had not yet occurred. Production finishing was the only outside vendor who polished steel bumpers for the autos. So the autos either polished in-house or they outsourced to production finishing. Those were the only choices. Ford Motor Company in 1981 was considering getting out of the polishing business, and Shields, on behalf of production finishing, was trying to get the business for production finishing. However, Ford told Shields that it would not outsource to production finishing because Ford did not deal with monopolies. Shields then asked Ford if it would deal with him if he started a new competing polishing business. Ford said yes. Shields then, over the next 3 to 4 months, while he was still a production finishing employee, reached an agreement with Ford to buy Ford's polishing equipment and to do polishing for Ford. And Shields formed Flat Rock Metal and found space for it to operate as a competitor of production finishing. Then on the same day in 1981, Shields notified production finishing that he was quitting, and he began operating Flat Rock as a competitor and doing business with Ford, and then later with all the other autos. Production finishing sued for theft of a corporate opportunity. Shields defended at the first trial in 1984 on the basis that Ford refused to deal with production finishing, and that as a result, there was no there was no production finishing opportunity with respect to Ford that he could possibly take. Shields even had a senior Ford vice president testify at trial that Ford would have never dealt with production finishing because it was a monopoly. The jury ruled for Shields and found that Ford was not an opportunity for production finishing. Production finishing then appealed. My firm, Honigman, was not involved in the first trial and did not defend that appeal. However, during that appeal, Shields consulted with Honigman about his chances on appeal. He came to James K. Robinson, who was then the head of our litigation department and had been the U.S. attorney. Jim later became the dean of Wayne's Law School and then the head of the criminal division of the Justice Department in Washington. Jim got me involved. We looked at this and then had a frank conversation with Shields and told him that he was at serious risk on the appeal and that he should settle. He did not. The Court of Appeals in 1987 then reversed and found Shields liable as a matter of law, held that he was not permitted to rely upon the refusal to deal defense because he did not give production finishing the opportunity to test that purported refusal to deal before he took the opportunity. And the court ordered Shields to disgorge every dollar he made off that Ford opportunity. And they remanded for it to trial to determine the amount. We then got hired to defend Shields at the second trial. The judge who presided over the first trial and who was set to preside over the second trial was Wayne Circuit Judge Charles Kaufman. Many of you may know his son, Rick Kaufman, who later became the chief judge of Wayne Circuit and then a very accomplished mediator. I believe he's the deputy county executive for Wayne County now. At the first trial, we understood that Charles Kaufman had seemingly been favorable to Shields. So we devised a strategy to hopefully take advantage of that. On remand, we filed a motion to strike production finishing's jury demand on the ground that the remedies it sought, a constructive trust and disgorgement, were all equitable remedies that needed to be decided by the chancellor in equity. Production finishing opposed the motion. We then asked Judge Kaufman to take our motion under advisement and not rule on it, and to instead conditionally impanel the jury and then decide, after the jury comes back, whether to grant our motion and disregard the jury's verdict. We were asking for 2 bites of the apple. And we cited a Michigan Supreme Court case that was on point that said in this circumstance, where there's a dispute over whether there should be a jury trial, this is exactly what a trial judge should do. Judge Kaufman did what we had asked, and he took the motion under advisement and conditionally impaneled the jury. Jim Robinson and I tried the case. At inception, the jury was instructed that Shields unlawfully took a corporate opportunity and that he was required to pay over to production finishing the benefit of that he had obtained, that they were to determine the amount. In effect, the jury was told at the inception of the trial that Shields was a thief. That is not an easy environment in which to try a case. And by the time of the second trial, Shields' new company, Flat Rock Metal, had been polishing for Ford for about 8 years, and he had made a ton of money doing it. We argued that production finishing was not entitled to get the money Flat Rock and Shields had made off the opportunity in perpetuity. Instead, we said there had to be a cutoff, in that production finishing was only entitled to the benefits Shield obtained during his improper, unfair head start or jump start that he had over production finishing. We argued that production finishing should not be entitled to the disgorgement of the benefit he received once production finishing had the opportunity to compete for the business after Shields' unfair jump start had passed. We argued at some point there has to be a cutoff to the claim. And we argued that that cutoff should be just a few months after Flat Rock Metal went into business, because at that point in time, or by that point in time, production finishing had the full opportunity to compete for the business. And we argued that this was consistent with the Court of Appeals decision, which had said that had Pete Shields disclosed to production finishing the opportunity before he pursued it, he was entitled to do so. So in our view, we argued they only ought to get the unfair head start. The trial lasted 2 to 3 weeks. And as I said, Shields had made a lot of money polishing steel bumpers for Ford. The jury came back with a $3 million verdict, which was about 50% of what production finishing had requested. And because this was back in a time of high inflation, the judgment interest statute at that point was 12% compounded annually. And the value of that verdict when interest was added was $9 million, triple the $3 million. We then asked Judge Kaufman to grant our motion to strike the jury and decide the case as the chancellor in equity without regard to the jury verdict. Judge Kaufman granted our motion and held that the jury verdict was entirely advisory and then totally disregarded it. He found that Shields' improper jump start had lasted for only about 6 months. He determined that the benefit Shields and Flat Rock had obtained was only about $300,000 during this 6-month time period, and he ordered them to disgorge only this much lower amount. He then also disregarded the judgment interest statute and awarded a much lower simple interest rate so that the value of the judgment was maybe $500,000 instead of $9 million. Production finishing appealed. And then during the pendency of the appeal, the case settled. And it settled by Flat Rock buying production finishing and becoming the monopolist and becoming the sole vendor to the autos who did polishing. And Flat Rock's business after that settlement then surged as truck sales skyrocketed. And that's because trucks have chrome bumpers that needed polishing. So at the end, Shields succeeded. He successfully took the Ford opportunity and started a competing business that ended up becoming very, very profitable. So that's the backstory of production finishing versus Shields. I'm happy to answer any questions on it. I have not taken up my full time, and if people want to do chats, that's fine. If they anybody wants to pipe in and just ask a question verbally, I'm good with that as well. But that's the backstory of production finishing versus Shields. Things do not always end up as one would suspect. So I just got a question in the chat. Is there case law that supports the Head Start theory? Unfortunately, we have not retained our our Shields files from way back then. My recollection is that when we briefed the issue, we had to struggle a little bit to cobble together law in that regard, but that it made sense from a common sense standpoint. And we had some law that we kind of cobbled together, but I don't recall that there was anything on all fours. And I certainly don't recall that there was anything close to on fours in the state of Michigan, but that's based upon memory. Anybody else have any other thoughts, questions? Any of our good professors want to weigh in on their thoughts? Well, I can tap dance. Oh, I just got to ask the question, is the company still in business? Yes, Flat Rock Metal is in business and has grown and is polishing a lot of bumpers. They've actually expanded into other areas as well. Well, let's see, with that, I got to ask the question, in what capacity was Shields offered the opportunity? He was the president of production finishing, and he was pitching Ford to get the business for production finishing. So in one of those meetings when he was completely striking out, he raised the subject of whether they do business with him if he formed a competing company. I also got asked if we used experts. The other side had experts on the valuing of the opportunity. My recollection is that we did not have an expert on the length of the jump start. I might be remembering wrong, but I don't believe we did. I believe there was testimony that nothing precluded Ford from moving its business to somebody else. We did not have a long-term agreement with Ford, and therefore Ford could move whenever it wanted, and that production finishing could compete on price or on any other basis if they had wanted to. So I got asked how the production finishing case has been applied. It's been, I mean, it is cited a zillion times. It's cited around the country, and it is, viewed as the very harsh result that happens if you take a corporate opportunity without disclosing it before you run with it. I got a question from Sean Desai, which is, didn't production finishing then receive its shot at the opportunity in as much as they discussed it first with Shields in the capacity as president? That was the argument at in the Court of Appeals the first time through, and the Court of Appeals rejected the defense, the refusal to deal defense, as a matter of law, and the defense that the opportunity was not production finishing's opportunity because of the refusal to deal. And the reason was because Shields had not disclosed it to production finishing before he pursued it. Production finishing did not have the opportunity to test the refusal to deal, and therefore they would have to take Shields' word for it. And the court said, therefore, the defense was not available.
Bill, that's typically how I teach those types of cases. The third party might not want to deal with them, but you can't be the one to make that determination, right? You've got to give them the opportunity to figure it out and get the requisite, whatever, disinterested approval, but give them the opportunity to fully develop it. And I always ask the class, what would you, what did the corporation want to have happen, right? They would have wanted the opportunity to see if they could have done it. But does that affect how you advise going forward? I mean, was there anything sort of on a prospective nature? I mean, how often situations come up where you're consulting them, and did that change? I guess that experience, did that change how you advise going forward?
Oh, yeah, absolutely. I mean, it is, if you run with the opportunity without disclosing, you're in a world of hurt. So the problem with the production finishing decision from a practical standpoint is that if you're someone in Shields' position, what the court effectively held is, you need to quit and then go out and see if you can get the business that you think you can get. But you have to go out naked, so to speak, and then see if you can get it, which is a very different difficult standard. Somebody else just asked, what does litigation from start to end cost Shields? It was expensive, but as a cost of doing business, it was peanuts. And when he started the business, he had a competitor where they could engage in a bidding war with customers. And after he bought out production finishing, his margins improved, of course, because he didn't have a competitor. So the result of the settlement was the business model changed in his favor. Well, I guess we're going to end 5 minutes early. Thank you, everyone. Anybody have any additional questions, you can email me or whatever. And again, thank you to the two professors for an excellent presentation. Appreciate that. And thank you, Mark, for putting on the session.
To close the night, please welcome Ian Williamson, who is going to present on something which we promise is not a secret society, the Oppression Study Project. This project is examining and making recommendations on the state and how it should be applied from both legal and policy perspectives. And Ian is going to share with you his involvement in this program and some of its recent work. Ian, take it away.
Good evening, everyone. I hope everyone can hear me. I've got my phone microphone on, so I'm sure someone will let me know if this isn't coming through. Eric, since I'm not able to actually have my picture large on the screen, can you just go ahead and start and put the first slide of the PowerPoint presentation up for this? That would be great, thanks. So I'm here tonight to close out the first night and talk to everyone about the Michigan Oppression Statute Study Project, which is something that has been going on for the last couple of years through the State Bar of Michigan's Business Law section, specifically through the Corporate Laws Committee. For those who don't know me, I'm Ian Williamson. I'm an attorney at Mantis Honigman. I've been practicing for about 16 years, primarily in this area, handling disputes among owners of closely held businesses. I've worked on cases with many of you. I've worked with several of you, and this symposium tonight has been fantastic. This is a great group of highly experienced people with a lot of good insight. I got involved in this Michigan Oppression Statute Study Project by virtue of being a member of the Business Law Section Council. I heard about this through the Corporate Laws Committee, which is headed by Justin Klimko, who many of you probably also know. At the time this study project was put into motion, it was 2018. We were coming up on about 30 years after the Michigan legislature first adopted MCL 450/1489. During that time period, we had a few changes from the legislature. We had some tweaks in 2001, 2006. We had the member action statute introduced in 2002 and tweaked again in 2010. But as we all know, there was only a handful of published case law at this point in 2018. And we had Estes, we had Franchino, we had Medigula, we had Frank v. Linkner, which is a member action case. But other than that, there was not a lot of guidance outside of a growing body of unpublished case law that doesn't always tend to be all that consistent. So with this limited guidance, attorneys representing plaintiffs and attorneys representing defendants, I think have often disagreed over the last 5 to 10 years as to whether the statute is better for the other side. Defense attorneys will sometimes point out that oppression lawsuits are rarely dismissed under MCR 2.116C8, for example. There have been complaints that I've heard that it is too easy to tie up companies in litigation for plaintiffs. That gives plaintiffs an advantage in oppression cases. On the plaintiff side, plaintiffs' attorneys have argued that trial courts sometimes fail to look at the big picture and will dismiss oppression claims after determining that individual actions considered in a vacuum don't necessarily rise to the level of oppression. I've also heard that it's too easy for defendants to use company funds for defense, and that plaintiffs don't typically have the same level of financial resources, and that puts them at a disadvantage. Well, Justin Klimko, who was the head of the chair of the Corporate Laws Committee, decided to do some actual examination and study of the statutory language to determine whether this statute could be improved. By 2018, it had been a little over 10 years since the last revision to the statute. Justin has had involvement with the development and interpretation of the oppression statute for some time. He is a former chair of the Business Law Section Council, is currently the chair of the Corporate Laws Committee. He was a participant in the drafting and editing of the Business Law Section's briefs that were filed in both the Estes and in the Matagula cases. Eric, could you put the next slide on, which is the oppression timeline slide? So in his capacity as the chair of the Corporate Laws Committee, Justin convened a group of experienced attorneys from the Business Law Section to assist in a broad review of the shareholder action statute and the member action statute. And this group included a mix of transactional attorneys and litigators. A number of participants in the study project, I believe, are present and attending the symposium here tonight. And in addition to putting together this group of attorneys to participate in the project, Justin also enlisted Professor Michael Molitor from Western Michigan University's Cooley Law School. Professor Molitor spent 10 years at Warner Norcross. He's published extensively on business organizations and corporate governance, and he has put a lot of work into the oppression statute study. So after putting together a group of participants and enlisting Professor Molitor, Justin put together a number of resources for us to kind of get the group started, including various articles on oppression, the briefs that the Business Law Section had published and or filed in the Estes and in the Matagula cases, and Justin scheduled an initial meeting in September 2018 to have some early discussion to nail down specific issues about the statute that could merit some further study, and to basically decide on parameters as to how the project was going to be handled. In advance of that meeting, Professor Molitor put together an extensive memorandum that compared statutes from all around the country addressing oppression issues. It's an impressive piece of work. It was very helpful. I put together a memorandum with my former associate, James Buster, now at Miller Johnson, identifying all of the then existing published and unpublished case law in the state of Michigan that applies or analyzes shareholder action and member action statutes. So we all had all of these resources before we came into the first meeting. Justin circulated a list of some initial questions to kick off the conversation, and we had that September meeting to decide what exactly this oppression statute study project was going to look like. So at the meeting, the participants discussed questions and criticisms about the shareholder action and member action statutes, including some of the ones that I mentioned at the beginning there, in order to decide what were the actual issues that people were concerned about themselves, were hearing concerns about from colleagues, or upon review of the statutory language felt were issues that were not clearly addressed by the statutory language, or maybe could supplement the existing statutory language. A lot of issues were discussed and ideas were discussed at that September meeting, and Professor Molitor, after the meeting was over, put together and circulated a survey to all participants so we could rank all of these different questions and issues in order of perceived importance. Everyone took the survey so we could figure out what were essentially the big issues that the most people were the most interested in addressing. And in February 2019, the study group met via conference call to discuss Professor Molitor's poll and determine how the group should address these study topics. So during that meeting, the group was able to identify specific topics for review and to assign them to 4 different working groups, or subcommittees basically, to research and discuss. The working group members were asked to consider whether their topics were adequately addressed by the statutory language, and if not, whether there were recommendations for proposed revisions to the statute. And let's jump over to the next slide, Eric, so we can take a look at what the 4 working groups ended up actually addressing. So we split into Group A, Group B, Group C, and Group D. Working Group A focused on fair value issues and the potential for adding a buyout provision. 450-1489, Section 1 enumerates a number of different potential remedies, and it includes the purchase at fair value of the shares of a shareholder, either by the corporation or by the officers, directors, or other shareholders responsible for the wrongful acts. This statutory language does not provide any guidance on how to interpret fair value, which, of course, is something that all of us have litigated extensively at this point. Specifically, there's no discussion in the statute as to whether or not this can include discounts, and up until we had the Franks opinion that came out last year, this wasn't really clear in Michigan case law. So all of us, I think, have probably gone back and forth on this in cases many times. That was a big issue during the oppression study group discussions, and that was a primary issue that people wanted to have addressed. So this group, Group A, discussed whether the statute should be modified to explicitly address this question, the question of how you determine fair value, whether you can apply discounts, whether that should say so directly in the statute, whether a statutory methodology or procedure for calculating fair value should be considered. This group also discussed whether Michigan statutes should include a buyout provision that would allow defendants to buy plaintiffs out in order to stop an oppression claim from proceeding, possibly with the court determining the buyout price if the parties were unable to agree. This would be really something like the no-fault provision that Mark Rossman raised in the comments earlier tonight. Plaintiff sues, claims oppression, and the defendants, if they don't want to litigate the case, the idea was perhaps there could be a buyout provision where the defendants say, okay, we're going to buy you out. Here's the price we're going to buy you out at, similar to the dissenters' rights statute, essentially. So Group B focused on interest as a shareholder and statutes of limitations. This group discussed the language in 450-1489 and in 450-4515, the member action statute, stating that adverse employment actions could be oppressive to the extent that the actions interfere with the distributions or other shareholder or member interests disproportionately as to the affected shareholder. The group focused on whether this language could or should be clarified to help differentiate between interest as a shareholder or member and interest as an employee, because there was perceived to be some need for distinction here between what a company could do legitimately in the employment context and when those actions started to bleed over into the definition of being an oppressive act. There was a concern that the language may not provide adequate guidance. Group B also considered the different statutes of limitations that apply depending on the requested relief. As we've heard discussed earlier tonight, we've got different statutes of limitations here depending on whether the plaintiff is looking for a legal remedy, in which case you have the 3 years after accrual or 2 years after the existence of the claim was known, or if the plaintiff is looking for equitable remedies, in which there's a 6-year statute of limitations. So Group B also discussed whether a case could be made to change these limitations periods, to make them uniform, whether to make them all longer, whether to make them all shorter, whether that was something that made sense. Group C evaluated the language talking about actions permitted by agreements. This group discussed the statutory language carving out conduct or actions that are permitted by an agreement, the articles of incorporation, the bylaws, or a consistently applied written corporate policy or procedure out of the definition of willfully unfair and oppressive conduct. Among other things, the group discussed the meaning of the term agreement as used in the statute, whether this is an agreement that requires all of the shareholders to have signed it or all of the members to have signed it, whether this could mean an agreement that perhaps shareholders or members had put in place at one point before other shareholders or members joined the company. The group also discussed whether the parties can or should be able to contract around the shareholder and member action statutes by disclaiming them, whether through shareholder agreements, whether through provisions in operating agreements. I know that I personally have seen these types of provisions in several different operating agreements. Others probably have as well. Others have probably drafted them that state things like the parties agree that they're disclaiming any remedies under MCL 450, 4515 for oppression. So there was a discussion as to whether those types of contract provisions are or should be legitimate. And Group D, which was my group, looked at standing and interplay with derivative actions. Our group consisted of myself, Dan Quick, and Ryan Opel. Dan and Ryan, I think, are both with us tonight as well. And what our group looked at was whether the statute should expressly clarify standing for shareholders or members who claim that they've lost their shareholder or membership interest through oppressive acts. That ended up being the easy portion of our question. And we also looked at the direct derivative distinction, whether the legislature intended to exempt oppression claims from all of the gatekeeping requirements that apply to derivative claims, like pre-suit demands, the potential for directors to secure independent legal opinions to insulate themselves from claims. And we also spent a lot of time talking about whether the business judgment rule actually exists in any way, shape, or form when it comes to oppression claims. Little did we know that we were foreshadowing what was going to happen in the Franks opinion that was coming down the pike. At the time, this was still a big question. And the reason that we addressed this issue was for the reasons that Professor Mull talked about earlier this evening. We have language in the statute that says that actions may be brought to establish that the acts of the directors or those in control were illegal, fraudulent, or willfully unfair and oppressive to the corporation or to the shareholder. And the enumerated remedies also include the award of damages to the corporation or to a shareholder. So we had some lively discussion about whether there could be an oppression claim that was asserting damages to the corporation, and if there were, should that really be brought as a derivative or as a direct action outside of the derivative context? So each group spent a number of months meeting independently, communicating via email, having telephone conferences. Our group met in person several times and had a number of email discussions. And the group members, by around July of 2019, had largely completed their initial analyses and come to at least some type of conclusions on the questions that they had been given. And the group members met via telephone on July 2019 to discuss each of their working group outcomes. So here's a key spoiler alert. None of the groups were able to agree on proposed changes that appeared to be both superior to existing statutory language and also unlikely to result in potentially negative unintended consequences. So no one was able to come up with anything that looked like it was going to be definitively better than the existing statutory language. But let's talk about what the groups did report and what the conclusions were. Eric, could you give us the next slide? So for Group A did not come to a consensus on whether adding a buyout provision to the statute was something that would be advisable. Group A did determine that it might be helpful for the statute to include a comment discussing things like the difference between the use of fair value in the dissenter's rights statute and the use of fair value in the oppression statute. Considerations for when a shareholder agreement exists or an operating agreement exists that has language that is controlling when it comes to buyouts or valuations, or considerations for courts to consider in determining whether to apply discounts. The group ultimately determined that care needed to be taken to maintain the court's broad remedial power and flexibility under the existing statutory language and case law. You know, the statutory language, of course, gives the courts broad authority, and then we have cases like Matagula that also state that courts have very broad discretion in determining the appropriate remedy. But adding comments to a statute is easier said than done. Professor Molitor looked into this after this working group meeting and determined that in Michigan there is no clear mechanism or process to add commentary to any statute, and that there really aren't official comments to Michigan statutes. So while this working group and our next group, Group B, both thought that this could be a helpful addition to the statute, it doesn't look like there is presently a way, a procedure under Michigan law to get this done. So Group B considered various proposed modifications to the statute, particularly to 1489 subsection 3, but came to no consensus on whether an amendment would be helpful. And some of the members of the group had concerns about unexpected consequences of changing the existing statutory language. This is a theme that I think that came up in probably all of our different working groups, especially because we have now had several decades during which courts have been interpreting this same language, and we now have business courts, at least during the past 7 or 8 years now, and the business court judges have been working with the statutory language for some time now. Group B also determined that it might be helpful to add a comment to the statute that could maybe specifically discuss employment-related decisions, perhaps with some examples. But again, we have the same issue where there isn't a procedural mechanism for adding commentary to Michigan statutes. Group B also considered whether a laches defense would apply to an action seeking equitable relief, because Michigan law really isn't clear on this, but if we do have the Matagula case clarifying that these are equitable claims to be heard by a judge, there's an argument there that equitable defenses like laches should apply to those equitable claims. The group did not come to a consensus on the statute of limitations issue and determined that this was really something that is probably best discussed in a much broader fashion. For Group C, the members of this group reported that they weren't entirely satisfied with the existing statutory language. There were concerns that a court could potentially find conduct to be oppressive even if the directors or those in control complied with all of the organizational documents. However, the group determined that there wasn't enough actual evidence of seemingly bad outcomes resulting from this language to justify proposing changes to the language at this point. And for Group D, for our group, the standing issue was an easy one for Ryan, Dan, and I to resolve. Looking at the existing case law, it appeared that shareholders do retain the ability to pursue actions under the statute if they contest the loss of their shareholder status, or for LLCs, the loss of their member status as part of an oppression claim. We were able to find several examples of cases in which these types of claims had been raised, and there did not appear to be any contrary argument, either from the other side or from the court. The discussion on direct derivative issues and the business judgment rule was a little bit more of a heated discussion, but we did not come to a consensus on whether the directors and those in control should have a stronger ability to secure early dismissal of oppression claims. But at the same time, our group ultimately did not come up with any potential or proposed revisions to statutory language. We had some of the same unexpected consequences, concerns that some of the other groups had as well. Eric, can you move us on to the next slide, please? So what happens now? This study project has been going on for a little over 2 years at this point. where are we at? Well, we had just a couple of months after our July 2019 meeting, we had the Franks v. Franks opinion come out. And of course, that completely changed the landscape for issues that multiple different working groups were looking at, including the business judgment rule issue in particular that was a heavy topic of discussion in my group. The oppression study group met in February of 2020, right before we got into peak pandemic, to further discuss the working group conclusions, to talk about the Franks opinion and how the Franks opinion interplayed with what the working group had been looking at, and to talk about next steps. And what was determined at that meeting was that even though the oppression study group and the working groups had not come up with specific ideas for proposed revisions to the oppression statutes, there had still been a lot of useful and interesting discussion and exchange of ideas, and that this was something that could probably stand to have a broader audience. So the upcoming issue of the Business Law Journal, which is being guided by the Corporate Laws Committee, is going to be largely focused on shareholder and member oppression issues. Participants from some of the different working groups have authored a number of different articles stemming out of their experience in these working groups, and these articles are going to be published in the next issue of the Business Law Journal. So I would say anyone who is a participant in this symposium should be watching out for this. This is highly recommended reading. It's going to be very interesting to everyone. Also, Justin Klimko has reached out to the business court judges on behalf of the Corporate Laws Committee to determine whether it would be helpful to convene a joint meeting of the oppression study group and business court judges to have a little bit more dialogue about some of the things that we've talked about in our working groups and with the oppression study group as a whole. So we don't know whether that's something that's going to happen, and of course with pandemic issues, having actual in-person meetings are more difficult to do these days, but that's something that's also a possibility for a result arising out of this project. And that's where the project stands today. I'm happy to answer any questions on this to the extent I can, but I do want to thank Justin Klimko in particular for being the person who organized this project and who has graciously allowed me to present on it, even though it's really Justin's baby that he's put together here. And I want to thank Professor Michael Molitor for a substantial amount of work and research in support of this project. Professor Molitor has really gone and Bruce Happy from the Business Law section for providing the platform for us to talk about this.
Thank you for attending night one of the 3rd annual symposium. And we look forward to seeing you tomorrow night for very relevant lectures on the prosecution and management of oppression litigation, to be followed by the Judges Roundtable and a special tribute to Oakland County Business Court Judge James Alexander. Thank you and good night.
Someday.
We'll see you tomorrow night. It's going to be better than tonight.
Lay down. Sunday, I remember things on Sunday. That way, yeah, way, that day. Someday, I wanna take a bite. Someday, I wanna hit the red dot and never back. Someday, oh.